case. Ms. Reed is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the
I decided to do a live stream because I was just outraged at what I saw going on when Judge Cannone said you cannot talk about ARCA in your opening. I could not believe it. This is so radical. It proves everything I was saying, which is the judge and the prosecutor do not want ARCA to testify at all. They know they cannot get this rigged conviction without excluding ARCA. ARCA killed them. They're dead in the water with ARCA testifying. Those two PhD experts, they're dead in the water, and they know it. And this is why this whole system's rigged. It's a sham court. And that's why you got a judgment. You can't even mention ARCA. Sixth Amendment constitutional rights are just absolutely crushed. They don't exist in this courtroom. This is not an American system of justice. This is an absolute outrage. And so I decided to jump on here, do a live stream, and note that there was a sidebar comment. You know why it was a sidebar? She doesn't want the arguments being heard how this is unconstitutional sham court. Right? That's what I believe Alexia was arguing. And she doesn't want that. Any kind of argument, the jury's not there. So what she's trying to do, she's trying to hide
the term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted.
No, you can't.
It is not enough for the Commonwealth to establish a...
I was just saying these reasonable doubt instructions are just full of confusion. They're very much antiquated. They're back from the 1840s and 50s, and they've never updated them. Massachusetts is so far behind the times. It's just really, really bizarre. And then to think that this is the part of the country where we've had our Constitution established, that the original 13 colonies, then you have this kind of court here that just runs roughshod and just tramples over constitutional rights of defendants. It's an absolute outrage.
Depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race.
Not for Karen Reed in this courtroom.
Religion,
over
age,
and over again.
ability,
She maybe
gender,
gets a little
sexual orientation,
of a benefit
education,
that she's owed,
income
but
level,
the main
or any
right
other
to present
personal
a defense,
characteristic.
they want it gutted.
You have
they don't
agreed
want
to be fair, and I am sure
about
that you
people in that
want to be
house
fair. But
being
that is not
suspects
always easy.
in the
One
cause
difficulty
of
comes
John
from our
O'Keefe's
own
death. They
built-in
gotta keep that
expectations
out
and
every way they
assumptions. They
can.
exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases.
They're already talking
Second,
about just making a
keep an
decision. They're
open
not going to
mind.
get to a decision for a
Avoid
couple
drawing
months. Why are they
conclusions
talking
until
about
the end
decisions
of the
now?
case when you
These
and
whole
your fellow
jury
jurors
instructions are very,
deliberate.
very bizarre here in
When you deliberate,
Massachusetts.
You will have all the evidence and all the
This is
time you
this is
need
unbelievable.
to make a
I
careful
cannot believe this is
decision.
in
So
America.
there
This
truly is no
is
need to
more like
start
some old
making up a rule
Soviet
before
type
then.
of
Third, you should listen closely
so-called
to all the
justice.
witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon
I did not see anything
unsupported
about
assumptions.
beaten and run over. Really? That's what Court TV's been saying, that Karen's accused of running over her boyfriend. So,
Than as members of a
wow.
particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender
I've never heard
identity
anything like this
groups?
either. We're talking
At
about
the end of the
different
case,
racial,
I will
ethnic
remind you of
groups,
these
trying to tell them not to be basically discriminating racists and stuff like that. I've
All
never
we
seen
ask
like
is
this
that
before in
you,
a jury instruction.
individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings.
That's all you
When
see
I
out of
finish
this
these initial instructions,
prosecutor in
the
court.
Commonwealth, Mr. Brennan, will
Bias and
make his opening
prejudice
statement,
against
then
the
Ms. Reed's lawyer,
Constitution, not
Mr.
just Karen, but the
Jackson, can choose to
Constitution,
make an
okay?
opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement.
Yeah, you would hope he
An opening
doesn't give
statement
one,
is a
right?
summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main
Yeah.
issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may
Yeah, this
present
judge
evidence on her
is a real
behalf
reason
if
why
she
this
wishes
whole
to
thing
do
got
so, but she is
ran
not
off the rails
obliged
the
to do
first
so.
trial, because the jury
Remember,
was
the burden of
confused.
proof is
He
always on the
picked a
Commonwealth to prove
former
that the
cop to
defendant
help
is
make sure
guilty.
this thing
The
goes
law
done
does
right.
not require
And
any
that cop
defendant to prove her innocence
got this
or to
jury
produce
confused
any
and got all
evidence
the
at all.
defense witnesses just to believe
After all the evidence, each side
they're
will
just
have
a
an opportunity
distraction
to
for this
offer you
jury, that
closing
you only
arguments
listen to the
about
government
what
witnesses.
conclusions
Anything
you
else
might
is
draw from the
distraction.
evidence.
Does that sound like a
Like the
cop,
opening
something a cop would
statements,
do,
the
trying to help
closing
out his
arguments are
cop
not
buddies?
evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous.
Yeah.
Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently.
All right. If they mentioned that he was run over, beaten and run over, he was not. I guess, is this what their new expert is coming up with? Is that's why they suddenly modified it in the last minute right before opening?
Whether you agree with it or not.
Wow, this is like.
Your function, you folks
Here's the
are
thing,
most important
folks.
people
The
in the
reason you
courtroom.
know
Your
she's
function
not
is to
guilty of
determine
this
the
is because of
facts.
the
You are the
desperate
sole
efforts they're
and
making
exclusive judges
to
of the
just
facts.
fling stuff
You
against the
alone
wall,
determine
to
what
hide the
evidence to
truth,
believe,
hide the
how important any
Constitution.
evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses.
This is why we need the Constitution, folks. This is what the framers of the Constitution set up. That's why we have the Bill of Rights. Because the old common law in England, you could not have call a defense witness.
It's entirely up to you.
So this is like basically the old
responsibility to resolve
way
any
of doing
conflicts in
so-called
testimony that may
justice,
arise
the
during
way
the
the
course of the
British did
trial
it against
and to
American
determine where the
citizens
truth
back then,
lies.
the British
Ultimately,
subjects.
you must determine whether or not
So
the
we've
Commonwealth has
reverted
proved the
back
charges beyond a reasonable
200
doubt.
plus years in this
The
courtroom.
lawyers have their own important
In
role in this
essence.
trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position.
The evidence,
They may also object to
bare
evidence
minimal
offered by the
evidence
other
that you
side
allow to
that may
come
not be
in to
admissible
defend
under our
Karen,
rules
the
of
major
evidence.
evidence you want kept
Similarly,
out,
we may
the
engage in
Constitution
sidebar
required
conferences.
evidence.
But to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is
Yeah, I've been
sustained.
talking over this. This
You are
is
to
standard
disregard that
language,
question,
and
you're not to
so
speculate as to what the answer might have been.
I'll turn the sound
In the
back
same
up.
way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer.
I've never seen a courtroom
This
with so many
happens a lot.
sirens.
You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn
Limited
testimony of
evidence
witnesses
belong to be
and may
presented,
also
so
include
Karen
any
Reed's not
exhibits that are
guilty.
admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So if a witness is asked, isn't it true that after you learned that your uncle left you money in
She's
his
a little
will, you
rushed in
poisoned
here,
him?
don't you think? She's going
And
a
the
little bit
witness's
fast.
answer is no. Based solely on that question and answer, there is no evidence
That's why, like Alessi did, you need to get up there. You need to constantly
that the
say,
uncle left the witness.
this violates the Constitution. You better have your case law ready to go to cite it. You're not going to find much constitutional case law in Massachusetts,
outside of
but
the
you need to
courtroom
cite federal
is not
case law,
evidence. My
and you need to
instructions
show
to you and
why
any other
she's
comments I may
creating
make,
reversible
the
error.
lawyer's
This
openings
case will
and
be
closing
busted on
arguments,
appeal. It's
and
such a
any comments they
trampling
may make
that
are not evidence. I will emphasize this point because it's
they
crucial to your
know they
understanding
cannot
of
win
your
the
role.
case.
If the lawyers
The
or I
judge has to put a
make any
lot of weight
comments
on the
during the
scale of the
trial,
prosecutors
those
to help
comments
tip the
are not
scales to
evidence,
their favor because
and
they
your
don't have a
verdict must
case,
be
folks.
based
They don't have a
only
case.
on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight
I
to
hope you
what
see a
that
whole
lawyer
different
does. In the interaction between a lawyer
mindset of
and a
these
witness,
lawyers.
you may
Granted,
consider
Alessi's
only
new.
the
They need to
witness's
like
testimony as evidence.
build a
And
record and build a
similarly,
record.
any
Call her
comment I
out on
make
it.
is not
Call her out
evidence.
on all
But
these
of course, you can't
unconstitutional
disregard what I say
deprivations.
when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view.
Yeah.
Now, in this case, I'm going to allow you to take
This
notes.
is standard
Any
instruction from
jurors who wish to
Massachusetts. It's
take
got some
notes
really
during the
weird
course of the
things
trial,
they talk
except
about,
during
but
opening statements and
I think it's a
closing
good thing they
arguments, because
take a
remember,
bus
those
out
aren't
there and they see
evidence.
how small that front
If you
yard
wish to
is. And to
take
think of
notes, you
all
may
these
do so once
people
the evidence
coming out of that
begins.
house and going
Notebooks
back in, come back out, none of them
pencils will be
saw John
provided to
O'Keefe
you.
laying in the
The
front
notebooks
yard.
will be collected each day, and
No,
they'll be locked up,
no juror
being
should find anything
confidential,
of the Commonwealth's
and they're
credible.
destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the
You better
case
take
involves many
notes. You better
witnesses
write down
or
all these lies of
complicated
the
issues.
Commonwealth
Notes
witnesses.
also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial.
Keep in mind, defense could reserve their opening until after the government rests their case.
Perhaps supplemented by your
So that
notes.
could be a strategy they decide to do, because I
Regardless of
like, look,
whether
if
or
our
not you
hands
take
are
notes,
tied,
please remember that
why don't we just
how
go
a
and
witness testifies may be
defer it? But
just as
I'm not a
important
guy
as
that
what
is
he or
interested
she
in ever
says.
deferring. I've never deferred
Therefore,
it.
your observations of
And
the witness's
so I
appearance
would
and
not pass
demeanor
on
on
the
the witness
opportunity,
stand
even
may
though
play an
you can't
important
even
part in
mention
your
ARCA
assessment
or
of his or
third
her
party.
credibility. Do not let note taking distract from
I'll just
appreciation
make sure
of all
you're
the
alleging
evidence.
that this is an
If you
unconstitutional
have any trouble hearing or
strangulation of
seeing
defense
during the trial,
argument,
please raise
and
your hand or
you
let a
want
court
to make a
officer know, and
record
we'll
and
make any
explain
necessary
what
adjustments. We
how
generally
your
take a morning
whole
recess at
defense is
around 11 o'clock or
basically being
so, but if
shut
you
down
need a
now,
break at
even on
any
your
other time,
opening.
please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me.
Keep in mind, this judge will pick the
Now,
foreperson
I'm going to
again.
address the issue of public
She knows from the
interest in this
questioning who
case
she
again.
thinks is most
It is
likely to
duty of this
convict.
court and
That's who
this
she's
jury
going
to
to
adhere to
pick
the
as a
rule of law
foreperson, the
because
person
it
she
is
thinks
so
can
very
have the
important.
most influence and
John
effect on
Adams
swaying
famously
the other
said that we're a
jurors.
government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the
If jurors do things like they
public
shake their
opinion
head
about a
when the
given subject
prosecution
may ebb
witnesses
and
say
flow.
something or
The
they
law must
make
be
any kind of
steady,
facial expression,
reliable, and
trust me, the judge's
even-handed.
marking it
We
down,
know that on the subject of
and
this case, there are people
there's going to be a way
advocating
they're
for
going to
one
try to get
outcome
rid
or
of that
another
person.
with
So they
great
better have poker
intensity,
faces on the
but
jury
unbound by
when they
any
have these
oath or even
unbelievable
any
government witnesses
inclination to
testifying, because
follow the
they're going to
actual evidence.
probably
The
have
law
some
works
kind
in
of
a different way,
reason
and the difference is crucial
that's
to
going
our
to get
system
them
of
booted from
justice.
being on the
This
jury.
jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have
Hello to
rights,
South
and we know that
Africa.
they have voices, but this trial will be decided by you. An independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the
Quote
law.
Donna
This is the
Adelson, this
only
is
way to ensure that
insane
every
to see this
person who
going
comes
on
before
here
the
in
court receives a
America.
fair
It's
trial.
really,
It is just that simple and that important. So while public comment will likely
any
continue, you
judge
must
watching
ignore it
this,
so
any
that the rule of
criminal
law will
law
be upheld.
practitioner would just be
Which
like,
leads me to the fact that it
wow,
is
this is
very
like so
important that during this
extreme.
trial, until you deliberate, you
Why would they
must
want to
not
go after
discuss this
somebody
case
and
with
just
anyone. This includes
strangulate
your
any
family and
defense from
friends
being
and
presented?
even your fellow
Any
jurors.
meaningful defense is
Nor
required
should
by the
you allow anyone to
Constitution.
communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the
Isn't it
matters in
so
this
wrong
case,
when the
and the
prosecution
individuals
will make
involved in this
efforts to
case.
hide the truth from the jury?
Not
Any of you
consult the
guys ever
internet or
on a
do
criminal
anything
case
else
on any
to
jury, you
try
think,
and
oh,
find
well,
out
the person's
information
guilty,
from
they
any
done it.
source
You got to
outside
keep
the
in mind,
confines in this court.
this never been this bad, but
Please be
prosecutors
very
are always
careful
doing
with your
stuff to keep
social
out
media
evidence
use.
helpful to the
Please
defense.
do not
All right,
use
so just
X
keep
or
that in
Twitter,
mind.
Facebook,
And the jury is
Instagram,
the
or
only
Reddit.
gatekeeper to
Though you may
prevent
never have seen anything about
the
this case
government from just running
before
a
on your
roughshod
social
and
media
trampling
feed,
over
you cannot
people's rights and
control what
putting
may
innocent
pop up.
people behind
You should also
bars
remember
for
that use
life.
of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go.
Think about it. This
Remember,
whole
you were
second
instructed
trial is
that you
because
must
you didn't
not
do your job.
discuss, that you would not,
Judge
or
Canoni
would
did
not
not do her
listen to
job
any
in
account
providing
of
clear
any
jury
aspect of this
instructions.
case in any news media,
Never
social
asked the
media,
jury, like,
or
how are you on
other
count
sources.
one?
It
How are
is
you on count
critical that you follow
two? How are you on
instructions.
count three? She just lumped them all together and didn't want to do any kind of peeling back the onion to figure out what exactly is going on here. Why can't you guys come up with any kind of unanimous decision on any of the counts?
And the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Wow. This guy's hired to give her a fair trial. Remember him saying that? That's what the Commonwealth said. Morphy. He's hired to get a conviction at all costs. That's what he's hired for.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter that a person's heart has stopped. He didn't know who it was. He didn't know where it was. He took his bag. He had just gotten to the station, and he rushed to the ambulance.
That's how you start your opening?
One of the most senior paramedics that morning. Another paramedic, Anthony Flamati, will be running this mission. He jumped in the back of the ambulance.
You can't talk about what happened with John O'Keefe. You start out talking about what other people were doing that had any relation to the crime itself.
You couldn't hear anything other than the engine of the ambulance.
The engine of the fire truck, you could hear him? And what?
It was near blizzard conditions.
This guy knows he's got to lose their case. Hide the truth, Brennan.
This is what the firefighters and paramedics.
Hide the truth. That's the only way you can win.
Focus. And he focused on his task.
Wow, focusing on task.
Make sure all tools were in place.
Did they put their boots on properly?
Meticulous as well. This was Anthony Flamati's.
Did they have enough gas in the engine, in the fuel tank?
He calmed himself and he thought about what was going to happen.
Oh my
What
God!
should he be looking for? What is his next steps? He played the scenarios through his mind.
How did he know where to go to find this person in cardiac arrest?
34 Fairview, the ambulance. He stood at the back door. The door's open. And he
Oh,
stepped
he's
out.
leading through how the doors open.
He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him.
He's talking about the wind, the blizzard.
Towards those screams in the darkness to snow. And when he got there, he saw 3 women.
Now notice he's not reading a script. Like I told the defense in their closing, get away from a script.
He walked up to the man.
If you don't know your case and you have to read a script, you shouldn't be in the courtroom. So this is something he's doing that is what experienced attorneys should be doing, but of course he's got no case.
And he walked over to that defendant, Karen Reed, and he told her that he thinks that man is gone. And then he heard the yell from Anthony Flamati, the chief.
He doesn't want to say how John O'Keefe got hurt. He wants to bury that.
Somebody's heart stops.
Bury that later in the argument.
Sometimes you can still save a life. So you'll see on a dash cam video, you'll hear from testimony. He went back to that man who's John O'Keefe. He went back to him, and that crew coordinated effort. They did everything they could.
He didn't say who John O'Keefe is. He doesn't mention that this is in front of a cop's house. A detective from the 30-year veteran of the Boston Police Department, Brian Albert.
And you'll see it on the video. Now,
I dare you to say that in your opening.
Because when you're trying to save someone, you want to know, are they on drugs, medication? Do they have a heart condition? And he looked up at Miss Reed and he said, what happened? And you'll hear her words to firefighter Nuttall. She said, I hit him, I hit him, I hit him. And it was at that time, through the words of the defendant, that she admitted what she had done. And she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context. They didn't reconcile with the injuries. They didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator. He is not a detective. He's a first responder. And so he takes that information. It was useless to him. He continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lays his cell phone. They bring him to the ambulance, and while they bring him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, I hit him, I hit him. Oh my God, I hit him. And then she was
He can't say what happened, folks. He can't say what happened. The only thing he's going to try to do is say Karen's word is what you have to convict her on, despite the forensic physical evidence in the bodily injuries that do not align with a car.
The defendant was a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate.
Yeah.
John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022,
he can't talk about her motive or his injury.
The defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole. You will learn that Mr. O'Keefe got out of the car. He got out as he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration.
Couldn't go that fast.
In the snow, the Lexus tires spun backwards. She went backwards at least 70 feet.
Now it changed to 70 feet.
He fell backwards, hit his head, broke his skull, and there he lay at the corner of Fairbrook.
He doesn't talk about how fast the vehicle went. It can't go that fast, especially in snow.
Lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe.
Hasn't talked about motive at all.
Senior and the brother of Paul O'Keefe. Grew up in Canton, worked hard, became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his home. They were his passion, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together. They did activities with the children together. She helped with
It's so boring.
Feeding the children. It was a steady relationship.
He hasn't talked about what led up to Karen supposedly trying to run him down with a car.
There was tension. There was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave. But she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022. You will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night,
He's doing a lot of pacing around the floor there.
they would go out together. I want to tell you something.
Very unusual for a trial attorney to do that much pacing. He's nervous. He knows he's got a garbage case.
John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Ways we've all heard of.
So think about it. You still don't really know what happened that night that got him killed, but led to this.
Ways is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare data. And the third thing, remarkably, it will be an expert in this case, who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar of visitors pending, and people are getting together in a celebratory mood. They go to McCarthy's and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrived at 8:50, they stayed till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. So that will be at least the 8th drink within 3 hours that you consume.
Look at all this pacing across the whole length of the jury there.
Not just cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, where there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the waterfall bar at 12:12. And you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, what we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to,
His timeline's all convoluted.
Jen McCabe tells John O'Keefe,
He can't tell a story. He's jumping all around.
Laura and Bella, or her mom, or somebody that John had dated before. And so as they make their way to Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the ways exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus.
He's jumping all around in time sequence because it doesn't make any logical sense of how things progress according to Commonwealth theory.
All the way to the end of the yard, in the corner where there's a tree line and a flagpole, and they reach that location at 12:34:33, and they're in the car and they stay there. The truck waits. They speak to somebody in the house. It comes out. The person goes back in the house, and they're for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside at 12:27, John gets a text from Jen McCabe. Park behind us in the driveway. 12:29, text again. Are you
This is so
coming in?
boring.
You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus.
No, I don't want to be
And in
slick.
20 seconds, you'll hear that user initiated. He looks at the phone, at the text message he Jen McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone.
Look, he's like a half hour in. He hasn't talked about why she wanted him dead. Enough of motive to want him dead. I mean, come on.
Last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see through the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops. Neutral.
Now he's back to
Shoots
feet.
into reverse, the tires spinning right towards him.
With tires spinning, how do you know how
Right when he got out.
much the car moved?
You'll know they're arguing because the next morning she tells
They
the
don't
firefighter, I'm sad because our last.
They don't have the evidence to back up these claims, so
She drives away.
exactly.
They said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, snow now picking up, and he's just there. It's 12:37.
He has no momentum, no steam.
Before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, drops.
Oh, great. We got a bad court feed here. I'm going to turn up the sound. Yeah, thank you. He's talking softly because...
She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking...
Yeah, he's jumping around on the timeline. He's not able to tell a story that makes any kind of compelling sense to the jury. They're sort of like, he's talking about all these different times, this and that. But if you don't, unless you take it in sequence, the jury doesn't want to sit there like have their mind in a ping pong machine trying to figure out all these different timelines and everything. And him pacing around like that, his tone of voice, just very grating. And so
cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message.
Wow. See, this is Massachusetts, so antiquated there. They can't even do a live stream feed. Wow.
Go back to him. She did not leave.
Yeah, he has no heart. I mean, he's hired to get a conviction, and as it's been said, 233,000 to date. He's hired to get a conviction. That's all he's hired to do. Not give her a fair trial. He's hired to get a conviction.
Walking to sleep, passing out. But then she wakes. It's 5 o'clock. She is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Out of deep sleep, she wakes up.
She's worried about him, Hank.
Jen. Screaming Jen's name. John's dead. Hank up the phone. Jen McCabe.
He is talking very silently. He doesn't have heart in this. These facts is being credible. He knows these facts are garbage.
I left him at the waterfall.
Lally isn't even looking at him.
You did leave at the waterfall.
He's not even giving him professional courtesy to look at him.
He then minutes later calls another person, Terry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids when they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead.
He's whispering. It's like Jen.
She calls hospitals. You can hear her voice. She's concerned. Not him. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Terry Roberts, the other friend, then goes to Jen McCabe's house, pulled behind the car. And when she does, she's on Bluetooth because she can hear the defendant saying, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road. Terry Roberts takes over and says, we're going to go back to John's house. He's in the house when you didn't see him.
Sounds like a stall.
So both cars, driven by Terry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Terry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Kerry Roberts comes into a room, she sees, rather than looking, the defendant simply
Hasn't talked about the injuries of John O'Keefe yet, has he?
At that point, the defendant
Hasn't presented any
insists they gotta go back
photos.
to Fairview Road. They decide to take one car. Kerry Roberts is taking charge. She's going to drive. They leave Miss Reed's Lexus and John O'Keefe's driveway, and they drive back towards 34 Fairview Road. Look there. It is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34 Fairview, you hear the defendant start to scream, "There he is!" Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door. "Let me out." Kerry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness, just where she left him. Kerry gets out of the car, starts to walk towards.
I'm glad the defense counsel aren't looking at him. Oh, now Lally's sort of turning.
She can't tell who it is.
He's not looking
His face
at
is
him.
still covered with snow, and she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes it's one of her best friends.
Wait a minute. Jen said they flipped him over.
And she starts trying to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits
Right
that
there.
cell phone battery.
Who's
It drops
lying?
50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall.
What about the Alberts in the house?
And when they lift him, that cell phone battery that is shut down to 37
That's for
degrees.
Bolton.
Kerry Roberts picks it up and puts it in her pocket, and it immediately starts to warm as she moves to help get a data. Show movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers.
I think
They're
we
not
got to
sure,
listen to
so
an
they
hour
look
of this
in the area where
garbage.
John's body is. They find a glass from the bar near the body. They find blood spots. They try to put the blood spots in plastic containers.
Some of the jurors are probably
They
thinking,
don't know
gosh,
what
I
they're
wish I
looking
would have
for.
figured out a way to get
No
out of this case. Listen to this
information.
guy.
They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work.
Oh, please don't freeze up with your high tech there, Massachusetts. Look, he's wearing a three-piece suit.
Out of the news, and they go to the hospital. They go to the Good Samaritan Hospital.
What's he wearing a three-piece
and Kerry
suit
Roberts
for?
is walking, and Peggy O'Keefe is going to go see her son from her husband. And as she walks down the hall, Karen Reed is also at the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked. As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you hear that Karen was excited and yelling.
He's not talking with enthusiasm and passion and a quest for justice.
Doesn't say a word. Peggy pays respects to her son.
He's walking the plank, forth and back.
Home because she has to tell the children.
He's got to regret signing up for this in some way.
Send an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see in the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home. A friend take it down.
Can't find the
And they
children.
bring the nephew
This is
home,
all
and
filler
he is
fluff.
distraught.
There's no riveting
And then Peggy
facts
hears
to
the
show
knock on the
Karen
door.
Reed's
It
guilty.
is the defendant and her father. They want to come in.
He wouldn't even talk about the
They
injury
come in.
on O'Keefe on his arm.
No condolences to Peggy. And they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs. They're upstairs for about 15 minutes. They come down. And quickly they leave. Now they got there from
47
the
pieces.
defendant's father.
But he's only talking about the one big piece.
That house. But when they leave, they take two cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. and you learn that.
Boy, I've never seen a guy
start getting
pacing
some of the
like this.
information. They learn about the broken tail light. They learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down,
Oh gosh! But think
you'll
about
hear from Trooper Lieutenant. He took a look. And you can see the missing
look how much of the time he's walking with his
They went in,
side
spoke
or his
to
back to
the
some
defendant.
of the jurors.
They took the car, they brought it back.
He doesn't want to face them head on.
And so, what to learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got into the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug the excavations, they found the shoe.
He's not talking about people going in and out of the house, leaving the party.
You learn days later when they did a plant excavation, they found his hat frozen to the ground. Over the course
Here we go, Massachusetts
of
high
that
tech.
broken tail light in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, took with her something of Mr. O'Keefe called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair.
I don't think he wants to look him in the face. Look at
Now, John O'Keefe fell backwards and hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor and neurosurgeon who's treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, not only cracked the skull, it's called a basal fracture, to create an injury called counter-coup. After he was hit by a car and fell backwards and hit his head on that hard rock ground. Remember, there's no snow, it's just a dusting at this point. The back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury,
you already said that.
with reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it undetermined. So we thought.
And why was he face down?
The renowned neurosurgeon does exactly this. You're also going to hear from an active reconstruction.
Yeah, so they had to get this guy out of
He'll
Miami.
come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant's.
So how did he wind up falling that hard and fast to wind up causing
There are three
a
charges
cracked skull?
against the defendant in this case. The first one, second-degree murder.
There's no bodily injury.
Murder, shooting somebody, stabbing somebody, bringing deliberate premeditation. Or I won't start doing the law. I'm not going to trample in that area, but I can tell you clearly.
None of the body
we are
injuries
not
line with
going
the
to try to
vehicle.
prove that
Right.
Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain and strong likelihood of death. That's what will prove to you second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She
He
hit
doesn't
John
believe
O'Keefe,
that.
and because she hit him and he fell back, she
Enough
caused his
trial
death.
to know.
The third
Garbage
charge
case from a good one. This is
No,
garbage,
yeah.
but there's a lot of
Again,
perks
she hit
involved when you
Mr.
hire
O'Keefe with the
someone
car.
with a hired gun
She knew
to
he
get a
was injured.
conviction.
She left him behind.
Why would anybody in this office,
That's the whole group.
DA's office, like,
This
wow, they
case
want
will
to take it and do it a
come
second
down to
time?
Science and the data.
You
Science
2.0.
and the
Nobody
data
wanted this
itself
case.
is
There's a
the
reason
best
why.
story. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice.
How could you be accurate driving a car that fast
and that facts and
going
data
backwards?
will
This
lead
car
you
has
to
restraints
the
that
truth
keep
in
it from
this
going
case.
that fast.
But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25.
Walk the plank. Keep walking the plank, Hank.
And we had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent.
Science, you want the ARCA out, yeah. What a great litigator. The only way you can win is to keep out critical constitutionally required evidence.
To extraordinary intoxications, her admissions to driving the arrest, her admissions to being angry at dawn that night.
What about people in the house, Hank?
Her admissions that she told.
Morphy's never tried a case. He went from being a legislator to DA. He's never tried a case. He's never tried a case, Maya. That's why. He's not a trial attorney. He's a politician.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
He was drunk. She doesn't remember.
Ladies and gentlemen, I simply ask you to
Defense better
follow
play the
the
911 tape.
Follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the
Looks like he's
evidence
wrapping
that
it up.
will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight
Nothing
back
about
to him
John
in the form
O'Keefe
of
and
an
his
SUV.
injuries. That's all you got to
Flipped
do is
him,
say something
he
about
fell
Karen
backwards,
said. You're
he
hiding
broke
the
his
ball.
head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
What an inspirational opening. Wow.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
It's all politics. The judge is appointed by a politician. It's all politics if you don't want to follow the law.
May I? The evidence in this case
Alan Jackson here.
will establish above everything else 3 points.
Good, he's not reading a script.
There was no collision
There you go.
with John O'Keefe.
Nailed it.
There was no collision. There was no collision.
That's
John
passion that you
O'Keefe
need
did
to
not
see.
die from being hit by a vehicle. Period. The facts will show that. The evidence will show that.
Get away from the script there, buddy.
The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for something, for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation, a text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too.
See, now the jury's going to start wondering, wait a minute, why don't we...
That quote defines the lack
What
of
about
integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss.
Good point to make.
But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it.
What happened?
And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight.
Good point.
You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend.
He's got more conviction and tenacity,
and he's
definitely
been
more here in the
disgraced
opening than he
by his
ever
own
did in
agents.
closing.
Not by
So,
us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. You have any idea how hard it is for a state trooper to get fired? The evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Albert's house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture. But
that's
the
good to raise your arm like that,
you
help
will
show
learn
your
through the course of
conviction.
this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate. They were loving. They were in good spirits. Nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before, and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the Waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there.
Did you
His
hear that with
sister-in-law,
Hanks? Was she
Jennifer
spent on Hanks
McCabe,
opening?
was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night
So
together.
the prosecution left out all these kind
You'll
of
see
details.
video footage from the Waterfall which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction,
all the lawyers,
troubling
on the defense
interaction
are
between
looking at
Brian Higgins and John O'Keefe.
unlike Lally.
And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive.
Bring up the alibi.
He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV
bring up that she was at John's house at 12:36.
And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. Mm-hmm. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold.
That means
or
he wasn't
frost.
out there all those hours then. So where was
Ladies
he?
and gentlemen, the scientific
Someone's house.
evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer,
Mm-hmm.
and his body had to have been moved out into the cold.
Think about it. Snowplow driver never saw him out by the road.
And that's
there.
where ultimately at 6 a.m., Karen found him the next morning.
He had no
You will learn
frostbite.
that John did not have a single injury
it got down to 12
consistent
degrees.
with being hit by a car. Let me say that
Great
again.
point.
The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. Lapasada will tell you
Bring up
with
that
medical
12
certainty
degrees.
that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're
There you
not the
go.
result of being struck by a car
Wow,
or
that's
taillight.
great.
You'll take one look at these injuries and you'll agree with Dr. Lapasada. The evidence will show that these injuries are from an animal, like a large
Sure,
dog,
right now gets it. There's
like the
starting to
large
think
dog that was
maybe we've
inside the
been
Albert
duped
house
by
that
this
night.
Brennan guy.
You'll learn that Brian Albert
How the
has
heck is that
actually
a car
admitted
strike?
that his large dog, the family
You're
dog,
the expert
is,
to
quote,
see that.
not good with strangers. And of course, John, never having been to the house before,
Common sense will tell you that.
was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. Lapasada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. Lapasada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found.
Something very
The medical
archaic,
evidence will establish no hypothermia,
like steel.
no
or-
injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet
Yes.
from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked
Right
by
in
it,
here.
drove by it
It's all
to leave the
politics,
house, and
folks.
still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth. And he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did. And we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road?
Right.
You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge. But again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie.
His arm
And that
photo
science
tries
will
to
tell
up
you
there.
with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt.
Great.
I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation: a butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian
If you want
Albert,
to hear my
both
live
police
commentary, then
officers,
switch to a different
both
channel that
trained
has no
investigators, got rid of their phones. Both of them.
These are great points. He's really doing good
And
here,
what else
folks.
you'll learn, Brian Albert got rid of. Shortly after this incident, Brian Albert got rid of his house, the whole thing, just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night, and she was over at the Alberts' house that evening as
There we
well.
go, Jen McCabe.
She left the
Critical.
after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Cellebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google
critical
search that was
details you never heard from
timestamped,
Hank.
according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Timestamped.
9-day
2:27.
difference between the prosecution and the defense openings.
And then that search was also noted by the same Cellebrite program as having been deleted.
All these
The
hidden
evidence will
details
force you to ask,
on Hank's
why is there a
opening,
search on her phone?
missing.
Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone Hoslong to die in cold hours before John's body was ever discovered.
That is
A Google search she
huge.
denies making, and that she later, or at least it was
Shows
later
involvement
logged as deleted.
and knowledge.
Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body at Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe.
Jurors aren't asleep on this.
They'll have no evidence of it, mind you. None.
He's not pacing
They'll make
the
the
floor
claim.
like boring Hank.
We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another
Rushing
car
the
in the
prosecution, all
driveway.
these details that Hank left
This is
out.
5 hours after she dropped John off and he went into
Yeah.
the Albert residence. As a result, the taillight was
Not use the word
minimally
alibi.
cracked,
That's what I would have
but
done.
it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere?
All these
Her
good
mind was
details,
reeling.
massive details.
The evidence will
critical.
establish she wasn't giving anything away.
I haven't heard all
Everything was on the
36
table.
yet.
What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He'd gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him?
Totally
and that
normal.
video clip that you saw,
Normal
out of
behavior.
context, when she
Blame
said the
yourself.
words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home.
Drunk girlfriend.
And the
trying to
evidence will
piece
show
together.
that Karen Reed never said, I hit him. Never. not in the background of the 911 recording,
He's
not on
nailing
any
it on
dash cam
passion.
video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen.
Great passion, great
Officer
delivery.
Sarath, Mullaney, Good, Lank.
Good hand
EMT
movement.
Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him."
Way to be loud. Take control.
The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years long close personal friends with a young woman named Caitlin Albert. You heard that right.
Another
It's
Albert.
Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn.
I got some trolls
not
on
just
here,
coincidence.
folks. So I'm going to zap
That,
them permanently.
folks,
Obviously, I'm
corruption.
here for commentary.
And you'll see
Why
how
would I
far it went.
Present a
Michael Proctor was
law and
alone
crime channel
with
if I
all
was
the
just
critical
gonna be
evidence in this
quiet.
case, along with Karen Reed's phone, along with John's phone, along with video footage, along with the taillight material,
He's doing great
along with
here.
he claimed to
Perfect
recover evidence
passion.
from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it.
Nailing
he
a
submitted
lot
it.
of facts.
He did it all.
This is what Karen
That's Michael
needs.
Proctor. And he did it without any reasonable oversight.
He's on fire.
You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants. He lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight
Right.
before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene.
Great voice emphasis
You'll find that there
here.
were 2 searches. The first and second search found 0, nothing.
He's
Nothing
just
around
blown away
John's
his
body,
closing. He's like
nothing in the street.
crushing it here.
Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control,
You don't need to name the
suddenly
third party.
items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice.
Great.
By
Use your
independent
fingers
officers,
to count
came
as
up with 0.
well.
To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic,
It's like
by
they
the
walk
way?
into two
What
different
about this
cases.
DNA?
Hank is
that
talking
the
about some
Commonwealth
other
mentioned?
case, not this one.
They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show it was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn.
Yep, that makes sense.
5 unidentified males.
Great point.
Touching that shoe.
No frostbite.
You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide.
And I see he's not being objected to by Brennan.
But they're nonetheless back again trying to present the exact same theory to you in this trial.
It's got all this momentum now.
Again, the evidence will show that that is reasonable doubt.
You can't trust Brennan. His opening was just
Throughout
garbage.
this trial, the Commonwealth will
Didn't
try
put
to
all these
convince you of
details.
paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty.
He's in there roaring like a
human
lion.
affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the house and the utter lack of investigation speaks volumes about those who actually have something to hide.
There's not a reason to object, but just for
By
the
the end of
sake
this
of
trial, you'll
objecting, I could
conclude
see
that
Brennan
Karen
doing
Reed
that.
is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the
He's
only
actually
verdicts,
doing a lot of
all three
argument
of
in
them,
this
that are
opening
consistent
statement. You're not
with the
allowed to
evidence,
argue, but he's getting
the
away with it.
science,
So
the
got to
truth,
go for it.
and
Get it in there.
justice. Not guilty, not guilty, not guilty. Thank you.
He didn't get every
Thank you, Mr.
detail in, but
Jackson.
man, he
Folks, why don't we
crushed
take our
compared to
hearings?
Hank hiding the ball.
You are muted.
I am so pleased and happy for the Karen Reed defense team. I think that this is amazing that they look like they were really under the weather. They were depressed, demoralized last week, the last time we saw him in court. And I think he does look like he's maybe not had a lot of sleep, but he came on there this morning. He came in that courtroom on fire, and he really got those kind of details out there. And Hank, you compare that to Hank, just sort of pacing forth and back, talking slower, talking sort of softly. Even when I had the volume on full on this Law and Crime channel, a lot of times you couldn't hear Hank very good. Look at how well we could hear Alan Jackson. So he has like done the job that we needed him to do for this case. We don't know what happened in that sidebar. He was not able to talk about and mention ARCA in his opening. And I'm going to take it off of, hold on a second. I keep forgetting to take it off of presentation mode. So thanks, John. My brother John here showed up last night. And so thanks, John, for help kicking off this this coverage. I wasn't planning on doing a live stream this morning, and but when I saw this whole goat rodeo nonsense about ARCA could not even be mentioned in their opening, I told you folks, this judge and the prosecutor, they want nothing of ARCA coming in. They're trying to do a setup, they're trying to do an ambush, and they're hoping to get rid of these ARCA experts on some kind of technicality. Because the goal is to get a conviction by hook or crook, no matter what it takes, get a conviction on Karen Reed. Doesn't matter if it's going to get busted on appeal. This will never survive an appellate process. This thing is so rigged. It's such a farce. It's such a sham that I can't imagine this is even, that they would even do this in a setting where the world can watch. The world can watch this trial. All the true crime followers that were watching this, just you really can't see much of this elsewhere. I've heard that maybe the Delphi case was bad. Richard Allen, I don't know really much of anything about that case, but I can tell you that this is the worst I've ever seen it. It's so bad. You just basically don't have a right to present a defense in this case. So that's what I'm thinking, that this judge, they got to keep hammering away at the unconstitutional rulings of this judge. This judge isn't, it looks like, has to know the law and is just looking the other way and wants none of the constitutional protections for Karen to apply. She'll give a few tidbits of thing like not having a independent reader read transcripts, but this is all about railroading Karen into conviction. That's what it so looks like from my foxhole. So I'll go ahead and take your questions now. Sam, you're saying what's happening when they immediately come back on stream? I don't know which one you're talking about. I was talking about earlier when I had seen Alessi, upon hearing that Kenny mention ARCA, he asked to have 5 minutes, and the judge says, for what? He goes, to talk about some case law, which I was telling him, better have your case law ramped and raring to go here, to directly showing this judge's face, you are wrong. You are flat out wrong, Judge. So, and then we had that long sidebar that took more than 5 minutes, and that's when I said, I can't take this anymore. And then Leslie and John encouraged me to do a live stream, so I said, all right. So anyway, that's what got me here. I don't know if I'm going to do anything beyond these openings here today. But if so, I will. I guess so. They probably have a lunch break, so it's going to be probably at least an hour lunch break from the time the openings ended. Eddie Haskell. The Commonwealth wants to bury the truth and hide the murders in their ranks. Disgraceful. Use red emojis. Thank you, Tall Glass. If you have a question, red emojis, I can jump into it quicker. Jonathan Long, you're saying who would have the better opening statement, Carl? There's no comparison. Hands down, defense completely blew Brennan out of the water with their opening. It was actually in many ways more of a closing than it was an opening. An opening is only supposed to be like, this is what the evidence is going to show, and you're not supposed to do any argument. He got a lot of argument weaved in with the facts, and I don't have a problem with that as an attorney. I wouldn't object, but if I was on the other side, if I was a prosecutor. But the bottom line is, this is the opening we needed to see for Karen Reed for the defense, and we saw what a weasel type of opening it was for Hank. Old Bag, you're asking, can witnesses from the last trial watch the first trial? They'd be told they're not supposed to, but I think with a lot of witnesses and also jurors, I think they're going to be looking at social media even though they're not supposed to. Brooklyn Rules, NBA, who will be the first witness? Well, we have a totally different prosecutor here, so I think you might start out with Hank maybe wanting to go through the medical type evidence, because as soon as you get into fact witnesses, they got all these holes and just basically they got motives and all this baggage. So he's going to try to take witnesses that don't have as much baggage. So maybe the first responders or else some of the medical folks, trying to get statements of Karen in. He just wants to play Karen's statements over and over as many times as he can because nothing else aligns. But as AJ pointed out, the statements Karen made at the scene, number one, there's no recording of it. Number two, people didn't write stuff down and give it to the police or tell the police, oh, hey, she just admitted to hitting him. So it's just not credible type of information you have from the scene there. I'm not quite sure what AJ meant when he's talking about, when she says, did I hit him, any contact with him, that she's talking about the 6 o'clock time frame. I'm not tracking that one at all. But in the end, it's not going to matter because the physical evidence doesn't lie. I think Karen showed at the scene when they came across John O'Keefe, she was the only one that actually cared about John O'Keefe, which is really sad. She's the only one that desperately was taking measures to try to save his life. JC, when is the best time for them to highlight Karen's alibi being connected to John's Wi-Fi? During Jen McCabe's testimony, they can debunk her timeline with the facts. They need to bring that up with every single witness they possibly can that's going to give a timeline. And so Jen McCabe's timeline, they didn't even follow it in the closing argument in Lally for the first trial. Lally went with a different timeline. So he started with 12:45 in the beginning of the trial and used that for the different witnesses. And then by the end of his by the time he got to his closing, he switched it. He did that little switcheroo there. So yeah, I'd actually use the word alibi. So, but despite some of these things that I would add, overall, I'd give it an A for their closing. AJ got I'd say an A, while I would say Hank, he got more like a gosh, could he even pass fail? He wouldn't pass in my book. He's in the D to maybe F range. Wednesday, you're saying I'm already convinced from the opening it's not guilty. Would I need to be recused if on the jury? No, I'm sure some jurors already have the same opinion, but you need to keep your mind open and wait till all the evidence comes in. Openings are not evidence, but yeah, you definitely need to go and like, wait a minute, this is what we heard this from the prosecutor, sort of some rambling, disjointed mess, and then you hear this from this powerful, fact detailed, passionate argument. I'll call it an argument by Alan Jackson. So definitely you think I do believe that jurors believe both attorneys know what happened. They both know the truth, and one of them's trying to hide the ball. And definitely it looks like the prosecution is hiding the ball on this one. Andy School, you're saying AG had passion and conviction. And there, I noticed that Brennan's talking about the coup contra coup, and that's something you brought up on the channel before with your forensic knowledge. So if you want to add something about that here now, your comments on what Brennan mentioned about the brain injury, what his neurologist will talk about. Ryan B., can the defense come up with a creative way to introduce Colin without breaking the judge's instructions not to? Well, I think the judge says you can't accuse him as being a third-party culprit. I would not take that to mean, and I would still press to have him be called as a witness. He may not be called as a witness now by the prosecution, so I would try to call him as a defense. But you know what? If he's not allowed to be called by the defense in their case in chief, as we call it, case in chief means in your main presentation of witnesses as opposed to a rebuttal. So you have case in chief for the prosecution, then you have case in chief for the defense, and then you have rebuttal by the prosecution, and then any potential rebuttal by the defense. Yes, that's true. Those of us in the House right now, we don't think there's evidence there to convict. With this, if this was happening, most any court of America, Karen would not have been charged. And the more you look at the forensic type of information, the details of it, the more it just shows that they don't have a case. You can even think that Karen Reed is guilty of something, but there's no way they can prove it beyond a reasonable doubt. Yeah, when you got basically this judge trying to basically just put you in a casket as a defense team, and Karen went along with her, you got to come back and you better have some powerful words and a lot of passion and emotion to back up your words. Yeah, G. Lander, that's a good way of saying it. The details of the defense opening showed the lengths the Commonwealth is willing to go to hide the truth. And the jury, keep in mind, the jury has no idea how bad this really is, how much his judge is hiding evidence and argument. Miriam, you're asking, do you think Hank is literally and figuratively picking his wounds over lunch or just figuratively? You know, I would say he's got to try to have a positive mindset about his case. If you have like a loser mindset on a case, and you can show to the jury. But I think his opening just showed that the way he's paced around there, that he realized he probably shouldn't have taken this case. Yeah, he's if you compare the two openings, no comparison. So I think he realizes that. Fierce Like Frida, you're asking, do I think the jurors think the opening or closing is more impactful on their decision? What's my experience? I think they're, in a way, I would say they're both. I don't like saying which is more important than there. I think all three I weigh equally, because I don't want to have my foot off the gas on any of them. I'm going to do Vore Dyer. It's just as much detailed and That's how you really start out, by getting your connection with the jury. You follow through with your opening. You got to really nail it with the details, the passion that you have. And then in your closing, you can bring out a lot of stuff that the prosecution did that was hiding the ball, that was shady. The lies of their witnesses actually came out, because you really have the great summation of what actually happened. You're predicting what's going to happen sort of in your opening and voir dire. And then you're able to say, see, exactly, this is what happened. I told you this happened. You can trust what I told you was the real ground truth. And so I don't like to say one is any less important than the other, because they all got to be in sync. Spicy Sour, you're saying he started with the firefighter, so maybe him. Yeah, it could be him, or he may try to go with his Miami doctor, but I would think he's going to do one or the other. The ones that are going to say Karen said I hit him, that's the one he's going to probably try to do first, because he really has nothing else other than him trying to say she made these admissions. Eddie Mack, I love that AJ showed his teeth and didn't let this awful judge intimidate him. Rosemary, you're saying, assuming they can object in openings, why do you think the prosecution weren't objecting? Well, there's no basis to object other than the fact that he was making arguments. But like I said, there's a professional courtesy. You do not interrupt openings or closings. It's really, unless something's really bad, where something's flat out wrong. Like I had a prosecutor object one time to my opening. He said I was misstating the law, and then the judge said, "No, he's not. That is your burden of proof. Sit down, counsel." So that was you better get it right, because if you object and you don't have a sustained objection, you look like you don't know what you're doing. And if you start out looking like you don't know what you're doing, it can be quite an embarrassment. Rosemary Gallagher, you're saying Brennan's opening was all over the place. I was getting confused. Yeah, new jurors, they'd be like really confused. The way he's pacing forth and back, it sort of looked like he was lost. He's walking in a big circle of sorts, just sort of lost on what he's doing there. And in a way, it's probably true, because he's like, what the heck am I doing here on this case? But he's gonna do everything he can to try to like just go after the prosecution witnesses and going after objections, just trying to like cut him off. He wants the truth to be suppressed, because the truth will clearly exonerate Karen Reed. McRamblon, you're saying, can the defense still cross-examine people like Colin as if they're effectively a third-party culprit? How does that ruling factor in with the opening, closing, and experts? It remains to be seen. I think this judge is going to, you're talking about cross-examining, maybe she's going to actually say that you can't call him. If you can't bring him as a culprit, is she going to say that you can't call him as a witness? Hopefully not. But I think you might see Brennan not even call Colin Albert as a witness in this case. I think he'll have to be defense, because think about it this way. Brennan knows he's got real baggage with Colin. Colin's the one that had the healed knuckles, the bloody knuckles that were all healing. They're all scabbed up like around 2 weeks after this happened. Yeah, it looks like he was tired, but man, he had the energy to deliver a powerful opening. G. Lander, wants the Commonwealth delay putting Proctor on the stand to make Proctor seem even less credible after that defense opening. Yeah, they're going to try to bury him in between the witnesses. I mean, they're probably wondering, is there a way we can avoid him testifying at all? But yeah, why didn't Brennan mention Proctor and all his baggage, his corrupt investigation that was nothing but a railroad job? Sam, you're saying the clerk stayed in the charges. He was beaten up and ran over. Well, beaten up by Karen? I mean, really beaten up? Yeah, he was beaten up all right, but not by Karen. Pepper, you're asking, do I think everyone in Brian Albert's house was involved in the murder? Or did they find out after? It's wild to me that not one person sent a single thing. I'm not going to point fingers at anybody. I just think they need to talk about it in general terms. So who I think was behind it doesn't really matter. And I just think that the reasonable doubt is there that most likely something happened by someone in the house, because that is where he was kept warm. Now they got the issue of the body heat of John O'Keefe. I think that's very important to bring out. He didn't have frostbite on him. AJ didn't talk about the lack of frostbite, but they talked about the body temperature and saying how it's consistent with him being kept inside. And it's like they didn't want him to perhaps die in the house, because they would have known that cadaver dogs could smell that or something. So there's just a lot of things that they were scrambling with that you can argue makes it look like there was something to hide of what's going on. These people, middle-aged people, up in the middle of the night doing all this running around. Higgins running back to a police station he has no business in being at. Jen being up all those hours and different weird butt dials and missed calls. Supposedly there was a scramble going on. That's what the defense is going to be arguing. Laney, why was the mention of ARCA in the opening denied? Because I think the judge is looking to keep out ARCA completely, or just whittle him down. She's wanting to get him on a technicality that she can say you're not going to be allowed to testify. If she can, she's looking for a Rule 14 reciprocal discovery violation to say, well, guess what? You're not allowed to testify now. You didn't disclose something. You were hiding the ball with the defense counsel. So guess what? You can't testify in this trial. Old bag. I thought it was good that AJ didn't cuss. I think Hank looked bad using that language during the opening. I can just tell you, as a trial attorney, especially because I did most of my trials starting out in the military setting, I would not use any cuss words that came out through the witnesses and came out through the evidence. I would describe them, and so the jury would know what I was saying, but I would not say them directly myself. I'd maybe spell them out. So they know what I'm talking about, or talk in that kind of abbreviated format, but not say them out loud like that. And I just think in the proper decorum as an attorney in the court is that you don't stoop to the level of the witnesses with their foul, profane language. Okay, so Andy School, you're saying that you can say that John's brain injuries on the right and left parietal lobes don't match. They're from separate blows to the head. That's what brought you onto this case. So that's very critical information. Let's see what these experts say. If they're separate blows to the head, obviously that's another indicator it wasn't a car. This was some kind of beating. Face-to-face confrontation, hand-to-hand combat type beating or fight. Bisky, you're saying yes. Alan Jackson did a good job today. He mentioned reasonable doubt more. He had correlation in the story, voice intonation, a good job, and how we discussed before. Yes, this Leslie is not my wife, Leslie. So just to clarify that. Okay, here's some sound back in the courtroom.
2 men standing.
Yep, I agree.
Put us back in session. You may be seated.
Oh, hey, we're back live here. Okay, stand by.
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The Commonwealth calls Timothy Nuttall.
All right, I'm trying to figure out how to add back. Gosh, come on, Carl.
Watch your step.
Oh, hold on, I know what to do. I got to do.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now and hearing to be the
There we
truth, the
go.
whole truth, and nothing but the truth, so help you God. Sir. Thank you. You can take a seat.
Sir, could you pull the microphone down a little bit closer to you, please?
Yes, sir. Or yes, ma'am. Excuse me.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy
First
Nuttall.
responder.
I'm 28 years old. I've been a firefighter paramedic for ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and very young, so I started on the transfer side, kind of learning the job. I started primarily in the city of Chelsea, Everett, Malden, Somerville, up there. And then after a little while, I got my feet wet in the 911 side. So I was running BLS 911 in those cities as well. And then I progressed on to become a paramedic. So
Why do you have such an interest in being a first responder at a young age?
I kind of grew up in a first responder household. My father was a firefighter in a local town. So we spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there.
It's
So
just really odd to start out with this
I want to
kind of admission
Take us
by the
back just a little
defendant
bit
instead
when
of
you
talking
first
about
became interested in
how
training to be a first responder.
the
Did
motive
you
for
share
murder,
with us your
about the
first training was
injuries
as an
and the
EMT?
autopsy and
Yes,
all
sir.
that.
Can you
Very
share
odd.
a little bit with the jury what that entails?
All
so
that evidence doesn't help him.
to become an
It
EMT,
sinks the case.
like there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
Is part of your work in learning to be an EMT, you active in the field?
The initial training
What do we
is,
need all this
like I said, it's
training? We all know
mostly
what an
classroom-based, but
EMT
once you
does.
sit your national written test and you're able to pass all that and pass practical, then you're able to progress into the field.
And did you succeed through the EMT training?
Yes, sir.
At that point,
Motivation
did
for
you
being
decide
EMT,
you wanted
come
more
on,
training? You
Brennan.
want to proceed through the profession?
Yes, sir. So after a little while, I worked for about a year and a half in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
Can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
yes,
And how-
paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat different patients.
As you worked through your training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic.
Yes, sir.
Does the Canton Police Department in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department or the Canton
I'm
Fire?
sorry, the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to remain employed by the Canton Fire Department, you have to become and maintain a paramedic certification.
So when you would go to work as a firefighter or paramedic, was it always the same, or did you get assigned as a firefighter one night and a paramedic a different night?
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So for example, if a fire call were to come in the town of Canton, and I was assigned to ambulance 1 for the day, I would take all my equipment off ambulance 1 and I would transfer it to ladder 1, and then we would take ladder 1 to the fire call and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to ambulance 1, then we take on the role as EMS, right? Take my paramedic skills and put them to work in the town on ambulance 1.
Let me ask you one more background
He's being
question
thrown
about
'cause it
how
won't
the
stick
Canton
on
Fire
appeal
Department
for
works.
conviction.
When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically the engine of that district and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is everybody's in quarters and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022. I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning. So I left earlier than normal just to get in before the roadways got particularly difficult to travel, and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton.
Called it a dusting.
The roads were starting to get. They weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have 3. We have one for fire, We have one for investigation and we have one for EMS. The EMS tones went off and the lights came on. Whenever there's the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding. Basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
Not a
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that
So
ambulance.
what did you do?
So I made the decision. I checked with the shift commander, and I jumped on ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What
And
happened?
just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance 1 in the patient compartment. The other 2 gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my can fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They're all in 3 separate bags. But I just, on the way there, I just got in. I didn't know how their night had gone. So I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
We grabbed all 3 bags.
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So gathering all the equipment together that can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe a foot and a half by foot and a half to kind of peek up front. But again, I was so busy getting everything together, I really didn't notice, but I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors open, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor. So 3 pieces of equipment with me. And I stepped out of the back of the side of the truck. There's a back compartment, or a back door and a side door. I stepped out of the side door. And I immediately noted the wind had picked up and the snow seemed to be heavier. And I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily. And it wasn't great all around.
Was it cold?
It was cold.
What about the temperature?
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following the sounds. I couldn't see anybody yet. So I just kind of followed the sounds. And then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton Police. And I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton Police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So he was laying on his back.
Okay.
From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep. So I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. And just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse, and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
So after you touched his cold skin and you felt the carotid artery? Is that how you
Yes, sir. Carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. As I was checking that, the other 2 individuals on the ambulance came and met me, and they began doing the same thing just to check. Sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the 3 individuals that were there, and just said, hey, I just have found no signs of life. We're going to see the next steps. And as I was saying that was when Anthony Flamati, who is the lead paramedic on this, made the decision this is a workable cardiac arrest.
Let me ask you 2 questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter or paramedic Flamati's lead?
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter or paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
I want to ask you about a term you used. You said a hypothermic situation. As a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis. You're just saying it's a hypothermic situation because of why?
Just because of the conditions. He was extremely cold to the touch, and he was in the elements. We didn't know how long, so taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
But is there anything about Mr. O'Keefe's fingers or hands
And knew how long he
or
was
his
outside, but
face
never
that
passed it
gave
on
you any
accurately.
indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very, very.
Mean? I don't know. What does not perfused mean?
Sorry, there did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff, which can be signs of hypothermia and frostbite. And again, touching the neck. So typically when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamade called you back,
Yep.
Where did you go exactly?
So when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with that valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort,
Yes, sir.
a coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which is myself in this situation, and then your cardiac and medication administration, which is, that would be Anthony Flamati, that would be Tony. Just because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were giving, helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir. I was kneeling at his head.
While you were kneeling at his head, well, let me ask you a more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes,
Thanks
sir.
for
Very
not
much.
telling you the history.
Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. Typically the first questions that we ask: what medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? Kind of gives us something to go off of.
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up, when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged male middle-aged female, with blood on her face. And I, real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson.
I see. And when you looked up and saw that person and asked about any background, what did she say to you?
I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yes, sir.
Would you say hundreds or thousands?
Thousands.
Do you remember all of them?
I remember aspects of various calls, but not all of them, no.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting. I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit
Seems odd,
him, I
you're worried
hit him,
about
I hit him,
Dialogue.
Did you ask
with
any
the witness
follow-up
there
questions?
instead of treating
I really
John
didn't get a
O'Keefe?
chance to, because following that, the individual just kind of walked away, or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Why would you?
Have
be
you ever
doing
received
that?
any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any
He's
interest
doing
in
too much to try to
detective
help
work?
the prosecution.
No,
it
sir.
Do you have
seems
any
like.
interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical aspect of a cardiac arrest. I was stuck there. I couldn't get up and kind of follow up on that at all. I was there doing that ventilation.
Is it your job to investigate cases or simply to get information to help treatment?
Just the information.
When you go out as a firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get the patient up and onto the stretcher. And then from there, we can move from the stretcher to the ambulance.
After you lift him to the stretcher, tell us what happens next.
So we put Mr. O'Keefe on the scoop stretcher, and we were able to get him onto the stretcher itself and then off to the ambulance. From there, I maintained my role as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in. So I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway, so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could kind of hear it as you go to squeeze in breaths into the individual. You can kind of hear the secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck. We really quickly suctioned him, and then we were able to intubate him successfully to definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm, he was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him. So every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues are stripping the clothes off him, is your attention on the clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity of that tube staying where it is and not being dislodged, that is another key aspect of airway management.
As you're doing that, do you notice what anybody else, any of your colleagues are doing to help?
Like I said, they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But again, I was quite focused on that airway, just making sure that it was maintained and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye.
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
Okay. And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood, mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well, following intubation, and that was kind of there just to maintain his cervical spine. But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed
it is
care
important.
to Good Samaritan Medical's physicians and ER nurses. We were able to give a report to the physician of just basic what we've done, what we've given for medications. In my case, what he was intubated with, and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically his. He kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
Okay. When the defendant told you that she hit him, did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in perspective of your care?
Objection. Sustained.
Okay. What role did that information play in your care
Sustained.
after the defendant
Wow.
told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of took it, noted it, and moved on my aspect of the cardiac arrest.
Where's all that blood?
Have you had an opportunity at any point to see any video of that morning
easy to
taken
see.
from any source, police car, dash cam?
Yes, sir.
Okay. All right, I'd like to introduce a video stream.
So this will be in evidence? There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2. I'm sorry. It is Cruiser 683 Stream 2. I'm going to ask to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m.
All right, so this is a dash cam of a police officer's vehicle.
Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably those would be ambulance 1.
Yeah, so not what you presume. Do you know what they are, sir?
And those are the lights for ambulance 1.
Do you see the weather conditions as it's depicted on this video?
Yes, sir.
Oh, as you stood outside, was it same or different to how it appears in this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen,
Yep.
you'll see a straight item from the bottom halfway up the picture. Do you know what that item is
I
on the
believe
video?
that's a flagpole, sir.
Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep, there they are.
Could you stop, please? Did you see the first person in line now behind the person in front of the person with the blue hat?
I'm sorry, sir. Could you back it up like 10 seconds?
Certainly.
That's Karen yelling, Jen.
Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Who's upset there? Only one person's upset.
Could you stop,
I
please?
can tell by the body language.
After informing you return, is that after firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Okay. Please continue. Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, I hit him, I hit him, I hit him?
It was right there, sir.
Could you continue, please? Could you stop for a moment? There's no voices or noises from people coming through that audio. When you were there that night, throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
They're not picked up on the audio?
No, sir.
Please continue.
There's some green light there, a hue, but I don't think that's lawn that we're seeing in the upper
Sir, you're still at the
lower
flagpole?
left corner.
Yes, sir. I'm kneeling at the head of the patient.
Can you tell me the people in that house, the Alberts, completely clueless to all this going on? Brian Albert's room is right up there in the front. So they're bringing a stretcher. I don't think this guy's trustworthy, credible.
Are you included in
not
that
all
group
what
of
he
first
thinks he
responders?
remembered.
I am
he
not, sir.
said.
I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you. We can conclude the viewing. With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes,
Thank you. May I approach?
yes.
Thank you.
Okay.
Can I show you a photograph?
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach again, Your Honor?
Yes,
I'd like to introduce this as an exhibit, please.
okay.
Here also.
Only Karen's upset.
I'm going to hand you a.
Hold on.
I'm sorry.
Thank you.
Pardon me, Your Honor. May we publish to the jury?
Yes,
Right. From this video, you
Is
can
that the
tell
photograph?
Karen's the one that's
Identify it.
upset. She's frantic
Yes,
for
sir.
movements. They call these scratches, what, these taillight scratches? Get
Showing you a
real.
second photograph. I'd like to ask you some questions about it.
can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman?
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
No.
Okay, yes,
Thank you.
thank you.
With the court's permission, could I publish exhibit 2?
Yes,
Yeah, that's what I've been saying. Karen's the only one that acts normal there. Those are dog bites, not vehicle
And sir, that's you recognize is the area where you were helping to
Kill
treat
like
John O'Keefe.
injuries.
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
If we could take down that exhibit 2, Mr. Gilman. May I approach, Your Honor?
Yes.
I would move to introduce exhibit 3.
All right.
Exhibit 3, so marked.
With the court's permission, I'd like to publish exhibit 3.
Sure.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down. Thank you. Thank you, sir. I have no further questions, Your Honor.
All right. Jackson?
Here we go. It's going to be Jackson or here's Jackson. Don't need to ask a whole lot of questions to this witness. Just nail your points and move on.
Thank you, Your Honor. May I?
Yes, please.
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame within the last 3 weeks, within the last 3 months, last 3 days.
Within the last 3 weeks, I believe one the week after that, and then one last night.
One
Last night.
last
Not
night.
even last night.
What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No. No, sir.
Male, female?
One female, one, I believe, state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully,
Yes, sir.
whom you've met with several times, correct?
Prior to that, I believe only once or twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings with Mr. Brennan.
Okay.
But beyond that, I can't speak to.
What did y'all discuss 3 weeks ago?
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony, and that.
Yet he
sort
looks
of-
tired. They all look
Prior
tired.
to
They've been
today,
working
how many
hard
times
on
have you
this.
testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once
Talking about the attorney's
last year.
turn,
All right.
pretty
As a
alert.
matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year. Yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year? Said it
No,
was
sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay, but you just saw that, or
Wow.
you read that and went over that 3 weeks ago.
I believe so, sir. Yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, "I hit him."
So previously testified possibly to 2, but it was 3.
Okay. your memory is clearer now than it was, for instance, a year ago when you testified?
Repeat that?
Sure. Your memory is clearer now as you sit here that it was 3 times you heard that than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your
Wow.
memory get better
Okay,
with
he
time?
blinked, his
General-
eyes held him.
Your memory. I'm not talking about the
His eyes
the
closed for a
royal
long time. He
you.
squeezed his
Remember, you-
eyelids shut.
In certain settings, I mean, there are certain
Sign of
things
deception,
about
consciousness.
different aspects that I recall better than others.
Okay.
Right there,
And
he's
does
squeezing
your
his
memory
eyes.
tend to get better or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay.
All right, good to know.
You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony, and that was really the gist of it.
And tell me the specifics of the prior testimony that you.
Again, it was the how many times we had talked about saying I hit him. Again, it was 3 times. And then there was also the video that was just played.
How did you first report this to law enforcement?
I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
Not sure, sir. That was just the way that the conversation went. And I just, again,
Look at his forehead.
repeated what I said and what I remember from that morning.
Well, tell me about that conversation.
Why's
Did
he got
Mr.
all
Brennan
his
say
lines in
anything
his
like,
forehead?
well, are
He
you
doesn't. He looks very
sure
uncomfortable.
that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how
Goes
it
from
was
2
that
to
morning, and
3?
that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to, he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said it, that you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way, correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that firefighter Nuttall is inconsistent with your testimony today, correct? You
Yes,
agree
sir.
with that?
But that is how it went that morning, sir.
Okay, that's not my question. Let me see if I can do it again.
Trying to help himself.
I'm asking you, if you testified last year,
Yes, sir.
that you heard the phrase twice,
Mhm.
and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Did
Look at him close
well,
his eyes.
You were there.
Hold him down.
You say not to my knowledge.
Look at that.
meaning-
No, sir. We did not.
Okay, so it was just about the number of times that you heard the
I'd
phrase,
ask
"I
him,
hit him,"
why are you
correct?
closing your eyes every time I ask these
You
pointed
cleared that
questions
up
and
in
holding them
the
tight,
2
tightly
meetings, 3
shut?
weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just
Last night?
making sure that everything was as it had been. I mean, and by that, I mean, it was 3 times and that we were continuously making sure that everything was the way that it had happened that morning.
Everything was the way that Mr. Brennan
Maybe he's going
wanted
to
it
say
to
4
be.
times
No, sir.
last night.
The way that it was I remember it and I recall it happening.
Okay, so he asked you 3 weeks ago about how many times you heard that phrase.
When did you
Yes, sir.
first
You
realize it
changed your
went from 2 to
testimony
3?
at that time and said it was 3 times instead of 2 times. We agree on that.
And who did he notify?
Then he
He
called
has
you a
new
week
revelation.
later, or met with you a week later, and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Just a second. May I have just a moment, Your Honor?
Yes.
when did he go from 2 to 3? At what point did he go from 2 to 3? And when did he relate that to law enforcement, the prosecution's office? And who did
Okay.
he first tell about?
And when you
Aaron's
talked last night,
statements?
did you assure Mr. Brennan, nope, nope, nope. When we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times.
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is? I'm going to tell the jurors it was 3 times that I heard it.
That was what I heard.
Brennan knew he was
Did you
flaky
tell
on his
him
testimony.
that's what you were going to say today?
No, sir.
That's why he talked to
didn't?
him last night.
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him. I hit him. I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video?
No, sir.
Just the clip that we saw?
Yes, sir.
Okay. What did y'all talk about in relation to that video?
Mostly nailing down who was who in that video.
Okay.
Being the other personnel on scene, where I was, and that was about it.
He showed you the clip that you showed. He showed you the clip that you just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, "I hit him"?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
He's not
Yes, sir.
squeezing his
And
eyes
you
shut on
defined
these easier
that's the point at
questions.
which she said, "I hit him, I hit him, I hit him."
Yes, sir.
And that's in response to your question.
Squeezing a little
I want to
bit
make sure I'm
there.
clear about this. You asked, "Do you know him?"
Yes, sir.
And she repeated the phrase 3 times, "I hit him, I hit him, I hit him."
Squeezing his eyes
Okay.
more now.
We'll talk more about that in just a second.
Taking a deep sigh.
Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it.
Yes, sir.
And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video.
No, that was the way that I remember it.
Right,
That
not
morning.
a trick question. My question is much more simple. You were able to establish after 3.5 years now, exactly where you were and where Miss Reed was,
His memory
and
gets
who else
better
was
over time.
around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay. You testified last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes,
That could be done you said in the ambulance, it could be done in the hospital, it could be done in situ out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
It's not really a lot of care taken to preserve the clothing from an evidentiary standpoint in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up on the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever.
Mhm.
Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so.
Okay, so this happened in January of 2022, that same year in the springtime. You testified at a grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that
Forehead
testimony
isn't
for a second.
skinning as
You
much
testified at
now.
that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes,
That night that you responded,
it was.
we've just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove or somebody had to remove in order for him to be properly assessed.
I did testify that way. Yes, sir.
Okay. And you mentioned that your memory of that big heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case,
Yes, sir.
about that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
This guy's all over the place.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about
Why is he wearing a suit and tie?
what I had meant when I said appropriately dressed.
So you did talk about something other than just the I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Got it. The fact is, well, let me ask you a different question. Did Mr. Brennan tell you what Mr. O'Keefe was actually wearing
No, sir. Actually, I believe you did.
last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Wasn't wearing a hat.
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
He
And
doesn't remember
obviously,
that.
goes without saying, but I'm going to ask it anyway. That's not being appropriately dressed for the winter.
No, sir.
You indicated that you did notice certain injuries on Mr. O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the
Yeah.
right side of his head
I
as
agree.
distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened,
Yes, sir.
but primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it, over his right eye, often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that
Look
you
at his
noted?
forehead.
There were several. As I noted, they were on his
Who does that?
right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Look right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet. Right,
Got it.
right about in there.
Okay. And what did the scratches look like?
They were deep, infamously referred to them as furrows, but they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh.
Yes, sir.
Okay. Some biological material.
Mhm.
Is that yes?
Yes, sir.
And were they parallel? Meaning they were going in the same direction?
Yes,
Were there any scratches below the elbow? As
there
well?
were. Yes, there were. They were not as significant as the ones in the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they look like scratches to you. That's how you describe them.
They did.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you,
Okay.
sir. It was just kind of how I.
No scrunched up forehead,
Okay.
no.
But what you did was you did this motion.
Yes, sir.
As you said, there were furrows. And remember, there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent, right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it's consistent with a physical altercation as well.
Excuse me?
Objection to referring to past testimony before a question is asked.
So sustained.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
Sustained.
I couldn't hear that.
What are some of the causes of lacerations?
a laceration as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Oh, come
Can you
on.
answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute, please.
Oh, here we go. Here we go. Judge doesn't want this coming out. He says, I don't know. He says that he's been doing this for years. He doesn't know what a physical injury looks like from a fight versus a car being taken out of a human. A vehicle strike on a human body? That's just very odd. So if you notice this guy, his credibility, his body language says it all. If you just compared his direct testimony body language to his cross, this guy's completely rattled. He's completely disintegrating right there in the witness chair. And why is he wearing a suit? I mean, not even Brian Albert wears a suit. Why is he wearing a suit? Why is he increasing his testimony from twice Karen saying I hit him to 3 times? Why would he even think of that? How is this guy credible when he says his memory in over 3 years has gotten better over time on certain things? And he swore under oath the last trial. So if he swore under oath it was 2, now he's swearing under oath it's 3. That makes him a liar under oath. One thing I'll give Brennan credit for is he's not objecting a lot. He's had several objections here all of a sudden. They're getting into bodily injury and what it can mean. He doesn't want the truth coming out that this looks like he was beat up. This doesn't look like a vehicle type strike at all. So this witness is just going to say, I don't know. Of course he knows. It just makes it look like he's so much trying to help the prosecution. All right, just looking at some of your questions here now. Is somebody doing a sidebars tally? Do any of y'all trust this witness? I don't trust him at all.
Mr. Nuttall,
Like he's
we are
trying to
going
become
let you
relevant,
take break and
important.
back to this after the luncheon break. So this is
Sounds good.
the luncheon break. There's lunch here for you. I assume Tony is it here?
It is here.
Okay. There's lunch here for you. We'll see you in about a half an hour.
Okay, looks like we'll have
All right,
more
please.
discussions, or did the
Thursday,
judge already
November
decide it? And if he did give a prior statement, yes, RN, you're saying, how could it not be let in? You're right. The judge is trying to figure out a way to keep it out. It's important now, more important now to keep out stuff that's helpful to Karen's team. All right, let me get this straight here. All right, so let me go back to your questions. Really, this is their first witness they start out with out the gate, and this is any witness who says their memory gets better over time is automatically not going to be credible. To go from 2 to 3, it makes no sense. After a couple years, several years, not a couple months, not a couple weeks, after several years, all of a sudden his memory is better. Say, oh no, she said it 3 times, not 2 times, 3 times. So, all right. So basically, this is a loss for the prosecution right now. This first witness that they prop up can't even tell a straight story. Trying to reprogram the witness lunch. So I think that it looks like Hank called him up because he knew this guy is a problem witness for him. Going from 2 to 3 doesn't make any sense. Doesn't make any sense at all. And with this lunch break, what's Hank going to tell him now? That's something that AJ should bring up again when he gets on the stand. Who talked to you at lunch? So at what point again did he go from saying it? Karen said, I hit him twice to 3 times. What would trigger that kind of memory? So I think that's something when a guy's lying like that, we say, oh, really? What made you decide to, what made you realize it was 3? Well, what's he going to say? He's going to look like a fool idiot saying that. And then who did you tell? When did you first tell somebody that? I suspect it was the first time you met with Brennan. First, second time is when he mentioned, oh, by the way, it was 3 times that Karen said that. Yeah, I didn't hear how long the break was. Yeah, this witness. I think he should. Amelia Lillard saying Alan is allowed to ask this. He should be able to go into everything this guy testified to previously. Brennan knows it hurtful to the prosecution. That's how he wants to keep it out. That's what it boils down to. Stacy Q, you're saying to Hank, he said the scratches ended at his elbow. To AG, they were on his whole arm. Yeah, they were on his whole arm. We've seen that photo. Yeah, Nellie Vieira, you're saying he changed his testimony. I think it's clear to the jury. Yeah, this guy, it looks like he's trying to get his 15 minutes of fame or something. You guys saying 30 minutes? Wow. Okay. Well, I'm going to go ahead and take a break as well here. I'm just going to keep the live stream going. You guys can ask questions, and I'll come back sometime before the 30 minutes is up. Please keep your comments clean. Nothing mean or bullying. So I appreciate that. You guys are phenomenal about getting all these details picked apart. Defense should hammer the previous testimony. There's literally tons of inconsistencies. They need to, absolutely. So, all right, with that, I'm going to go ahead and step away here for a little bit, and I'll come back. All right, stand by.
All right, everybody. I'm letting Carl take a quick break. I'm gonna step in real quick. This is his brother, John. And I just wanted to say thank you all for joining in his live streams. Hope you like the studio. This used to be in my house, but we moved it first to Oklahoma. I'm out of breath because I've been running around. And now it's here in San Antonio, Texas. So if you guys notice any coloration differences, it's because I tweaked a few settings on this wonderful camera. But anyways, did you guys note the use of the word scratches? I mean, if you showed up to someone's house with that arm and you showed them that exact picture that you saw, the autopsy photo of John O'Keefe, would you call those scratches? Or as I maintain, you'd call those deep lacerations. You use words like that, or a deep wound. So I just thought that's peculiar that he would use the word scratches. And I thought, this is the first time I've ever seen this witness. And I thought, okay, this is just going to be a neutral witness establishing the grounds, the facts of what he saw. And it turns out, wow, it's problematic in my opinion. So I'm gonna look at some of these questions, and I'm doing this with Carl's approval. So I didn't hijack completely his thread. Where do I reside? I sold my house in Texas, and I now live in an Airstream in Las Vegas. Yeah, thanks, Andy School. It's the Sony FX30. So if you guys remember back in the day that Carl's camera would just suddenly shut off, I got him great cameras. The problem is none of them had built-in fans. So it was beyond the capability of those cameras. So I scratched my head going, man, we need to get a better camera that doesn't overheat. So finally found this camera, which is the FX30. It's wonderful. It's not even that expensive these days, and it just does a wonderful job. If anybody wants to do a live stream, I highly suggest getting that camera and a good mic. I've always said good audio is more important than good video. And I think you guys will enjoy think this mic's good as I do. Yeah, it's nice out there. I really love it. And I'm not a gambler, in case you're wondering at all. I just love the palm trees, the sunshine, the clear skies. In Las Vegas, 300 plus days of sunshine per year, and no state income tax. So those are some of the main reasons why I decided to cut and run out of Texas. Although here I'm back. I love Carl and Leslie's new house. It's wonderful here. It's only like 15 minutes from the airport. Another reason why I'm glad I got Carl into the case is because, I was born and raised around him, and the way he had a sense of justice and going after people. For instance, one quick story, I was bullied by this kid always going home from school. At one point, this kid took my baseball cap and threw it up into a tree, and now I couldn't get it. So I went home and I was crying. I told Carl a story how this bully says, let's go. Here's what we're going to do. We're going to go down there. And once you're going to knock on his door and get him to come out like you want to fight him. And then I'm going to take over. I said, okay, this sounds great. So I showed up, knocked on his door, and I'm not the fighting type at all. And I said, let's go. I want to fight you. So I backed up until Carl confronted him and just laid into him with his words in the way that only Carl can do. And I remember this kid was shaking like a leaf as he went and grabbed, I think it was a ladder or something. I don't remember how he actually got it down, but he got the hat down. And that's the kind of justice warrior Carl has always been. And for those of you new to this channel, I brought Carl into the murder of Dan Markell case a couple years ago. And unbeknownst to me, while I was just sharing with him the outrageousness of it and the whole story and the backdrop, unbeknownst to me, Carl was watching videos and getting caught up to the date. One day we're sitting around my living room talking, and I just looked and said, oh, holy Carl, I can't believe you know that this many details of this case. And of course, Carl had opinions on what's going on with the prosecution who's taken their sweet time at that point and still is, in my opinion, to go after everybody who's involved in that case. And I said, I'm going to get my cameras out. We're just going to do a free for all. I'm just going to record you answer my questions. And literally 30 minutes later, we were recording our first video. And that's what got Carl into this whole, true crime space. I would have never thought that he would be commenting on it, but here he is. I'm really glad he's here. I think you guys are also really glad that he's here to, with his valuable opinions. And I got to share something with you guys that he doesn't even know what I'm about to say, is that I had no idea how keen his legal knowledge was. I always knew he was one of these rare lawyers that has not just intelligence, but also ethics behind it. That's huge. Yeah, you can get a lot of smart people, but he's got ethics, and he thinks on his feet quick, and he's very common sense oriented. So even though I knew those things, he even surprised me with the breadth of how deep his abilities were in analyzing cases. I had no idea. So I'm really, really happy that Carl is now flourishing in this scene, and I'm glad he's covering this case. I'll be honest, I went from thinking when I first heard about this case that, well, she probably did it. What prosecution would go after somebody if they're innocent? That was my initial stance without knowing any of the evidence, to now thinking, wow, the complete opposite. And it's an outrage. So anyways, let me look at some more of your comments. You guys are really, really sweet. And again, thanks for keeping the chat clean. I'm not able to monitor all the lives because I'm a pilot, and I work about half the month. So I'm not always able. So if you guys sometimes wonder why some of the trolls are getting through, well, it's just the nature of the amount of times Carl's going live. And we've had to call some of our moderators in the past. So we don't really have many moderators right now. So it's really you guys that's keeping this chat clean. And if you guys aren't following the Justice for Dan Markell, I highly recommend you following it. It's a very complex case, and the grandma, she's in her 70s. She's on trial coming up in June. So just imagine a rich family who should be out there thriving, and she was thriving, and now she's behind bars in Tallahassee, California, in a jail, getting ready to face a prosecution there in Tallahassee. It's a really crazy story. That's right, Tall Glass. And by the way, a special shout out to you, Tall Glass. I really appreciate everything that you're doing. You are on the live streams, it seems like every single time. Yeah, Fancy Fiction is great. She knows so many of the facts, and she adds an element of entertainment that's unrivaled. Let's see. I also want to embarrass Carl a little bit. What's something trivial about him? Oh, he won't want me saying this, but Carl was a real formidable defensive end in high school. He got recruited by the University of Nebraska Cornhuskers. And unfortunately, his senior year in high school, he blew out his knee. And from that point, he was never back to his former self. So he ended up playing college football in Lamar's, Iowa. Can't remember the name of the college, but I remember Carl's tenaciousness in football. In fact, that exact word I just used, I learned that years ago from Carl. I'd never known the word tenacious, but it's so funny how that just came out. Yeah, so Carl was tenacious. He used that word, and I always loved that about him. And he always gave me, good career advice and stuff, and being out there and not just, going along with the river of life, but actually getting there, swimming, fighting, doing the right thing, and taking massive action. So, yeah, Crystal Rogers, that's another one that's got Carl in my interest. I was driving around that town in Kentucky because of I'm in Louisville quite a bit with my work. And I remember someone basically taking me aside. I don't remember his job, but it was something in government. And say, hey, buddy, you better be careful about what you're doing down here, as in potentially covering the case, talking about it on a YouTube channel. He didn't know about my brother's YouTube channel. So that was my first indicator that, wow, this city's sorry about that. There's something really going on here in Bardstown, Kentucky. And he was serious as a heart attack. He said, listen, buddy, you need to watch out what you're doing and who you're talking to and stuff like that. So that's the kind of shenanigans that are going on in that town. And I'm not sure if Carl will be following it on this channel, but it's a very interesting case and a lot simpler to understand than, for instance, the Denmark Hill case. So we're going to continue this live stream through today. Do you guys think it'd be better if we divide it up into mornings and afternoons, which would mean easier to category the testimony, but we'd be stopping this live stream and all the comments and starting from square one again. What do you guys think? Should we keep this go on through the full day with, of course, a interruption or a pause like this, or should we divide it into, let's say, mornings or afternoons? If you guys want to give your opinion on that. Still on the fence. Leave it going, says Loki. Also, if we end up going the full day, I'll end up putting the timestamps a day or two later. That way, in the future, people could easily click on the link or click on the description or a pinned comment on where to go. Old, hey, please. Yeah, what a trial. And boy, was that not a riveting opening statement by Alan Jackson? I've been on 3 criminal trial juries. I've never seen anybody even close to that. The defense attorneys were really, you could just tell they were showing up to do their job to the best of their ability, but they had no passion at all. And I think jurors crave passion. And during live court streams, that suggests to be live so we can watch. Yeah, we'll definitely be in that. My question was more along the lines of, do we divide it up into mornings and afternoons, or just let it go all day long, including, a lunch interruption like this where there's nobody on screen for 30 minutes? Yeah, someone says, no, I think you should break it up. This is the perfect time to make a new stream and redirect us to it. That's what the veteran YouTubers do it. There's probably a reason. That's a good point. So we got a little bit of a diverse opinion here. Yeah, thanks again, y'all. I'm gonna step off. Again, appreciate you guys following, and Carl will continue to give you his no holds barred commentary. Yeah, Carl's oops, here it is. Carl's, yeah, if you guys did not listen to him, and I already posted a quote on the post tabs of YouTube of Carl's summary, a 2-sentence summary of Alan Jackson's opening. And yeah, he did read a little bit of the script, but I think he had so many details to put out in about an hour that he kind of had to. So I thought that was okay. And just the way he wrapped up. The only thing I thought he missed, tell me if I'm wrong, but he didn't talk about the 1236, which to me cements an alibi for Karen. Yeah. You're welcome. And again, thank you, Andy School, for all of your commentary and help. All right. Okay. So guys, I'm gonna wrap it up. The testimony will resume shortly with Carl's guidance and opinion. Talk to you guys later.
All right, I'm back. Can you all hear me? All right. Okay, yes. I think it's amazing just thinking about this here on break. I'm just amazed that the first witness they have is Nuttall. It's really bizarre to put a witness up there who's not even done being cross-examined yet, but he's just coming across so terrible. He's not credible at all. And so he's got his body language says a lot because he's squinting his eyes like this when the most zinger type questions on cross come about. He's got a scrunched up forehead other times when he's really stressed out. And to sit there and say your memory improves in certain areas over time, especially years time. I mean, just basically take this witness and just toss him out. It basically highlights how weak the prosecution is. That's how they start out strong. Brennan is this is an example of why Brennan is so much focused on keeping Arca out, because that's his only chance through these terrible witnesses he's got for the prosecution that can't hold their stories straight and have any kind of credibility. The judge is not a friend of the Constitution, says Loki. Beezer talk about defense opening is one of the best. It was very good. Yes, I give it an A. Well, the prosecution opening was more like a D- or an F. Yeah, there's McRamble on. You're saying the law channels used to talk over stream to share immediate reaction, fill pauses, or give short bit of input, and now no one does. You like commentary and reactions. Well, that's what I'm trying to do here. There was a couple of people that were saying I just need to keep quiet and let them watch the arguments without any commentary. Well, if that's the case, then obviously they can just go to Law and Crime or some other channel where that's all they got. So trying to be like a play-by-play type of commentary like you see in sporting events. And I wasn't talking all the time. I was just interjecting different comments and observations here and there. So same thing with the witness. I'm not gonna continually talk over them unless they are just that bad and just rambling on forever and ever like Charlie Adelson did. Charlie Adelson, the convicted dentist, who's spending life without parole up in a South Dakota prison, being convicted in a Florida prison. McRamble, you're asking if I've heard about the prosecution dumping tons of emails on the defense. I've not heard of that. Only a bit of 30 days out. Not credible on better memory. Jury won't buy it most likely. I mean, I don't look at this guy as like an inherently bad person that's out to bring people down, but he seems like he wants to be important and relevant in some way. And the fact that he was right there, I'm just curious how his observations were passed on to the police and how when his story changed, how it was passed on to law enforcement and the DA's office. Maybe we'll hear still from that on cross-examination. Someone's saying they're back in court now. I don't see it. On the screen anyway. I mean, that's a common cross-defense tactic. Tactic is to say that your memory gets better over time because most witnesses, when they change their story and they have to have more details, then it's just a common thing. Whether you're prosecution attorney or defense attorney, you're going to attack them for saying, "Really, your memory gets better over time." Nobody's memory gets better over time. Yeah, I don't know how the O'Keefe family believed the prosecution. I think it's just hard for them to believe the prosecution could be that bad and really doing a number on them. Yeah, I'm not doing court TV. I'm doing law and crime. So court is back on law and crime. Okay. I know it's not showing up on mine. Hold on a second. Did they end that stream?
Have
Here we
access as
go.
invitees or licensees with a
I guess they ended
percentage
that
by weight of
stream.
alcohol in their blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor
No, I
vehicles
think
that the
that's the
lives and
first
safety
beginning of it.
of the
Sorry.
public might be endangered. And by such wanton and reckless conduct so described, you cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter.
Okay, I'm trying to.
And did so operate said motor vehicles.
Trying to see where they left off in the live.
Ed,
Or no. This might be it. Not sure if this is live or not.
May I, Your Honor?
yes,
Thank you.
please.
Firefighter Nuttall, over the lunch hour,
Here
did
we go.
you discuss anything that we had discussed this morning or earlier in the session with anybody?
Good question.
About the testimony?
Oh, sorry.
Okay. You did mention earlier today the EMTs that were with you that responded to the scene. You mentioned, I think you said Tony Anthony Flamati, correct?
Yes, sir.
You mentioned Kelly, and I want to say Matthew.
Matt Kelly.
Matt Kelly.
Yep.
Yourself.
Correct.
And of the three of you, two of the three of you were and are paramedics, our firefighter Flamati and yourself, correct?
Correct.
Do you know the name Katie McLaughlin?
I do.
Who is Katie McLaughlin?
She is a firefighter paramedic for the town of Canton.
Was she also on the call?
She was.
You didn't mention her this morning.
It did not come up. She responded on the initial dispatch on engine 3.
You were asked who responded with you, correct?
Yes, sir.
By Mr. Brennan.
Yes, sir.
And you mentioned yourself. You mentioned Tony Flamati. You mentioned Matt Kelly.
Yes, myself, firefighter Flamati,
This
and
is
firefighter
live.
Kelly responded in ambulance 1 together.
Okay. And how did firefighter McLaughlin respond?
So she was assigned to engine 3 that night. She was with Lieutenant Woodbury and firefighter paramedic Frank Walsh.
Is she also, in addition to Walsh being, it's Frank Walsh?
Yes, sir.
In addition to firefighter Walsh being a paramedic, Katie McLaughlin was also a paramedic.
Correct.
So she responded to the scene at the same time as you, generally, but in a different ambulance.
In a fire truck, in a piece of fire apparatus. She was
Got
in
it.
engine 3.
Got it, engine 3, okay. And she was with you, generally, when I say with you, at the scene during the entire time that you're describing the events that you described with Mr. Brennan on direct examination.
For the most part.
Okay. She then left in a particular ambulance, correct?
Yes, she ended up driving ambulance 1 to Good Samaritan.
And ambulance 1 was which ambulance?
Ambulance 1 was the initial ambulance that myself, firefighter Kelly, and firefighter Flamati responded in.
So right after the scene you described, as you're leaving the scene, firefighter McLaughlin is in the ambulance with you and firefighter Flamati, correct?
She is driving. So the three of us are in the back in the patient compartment. She is up front in the driver's seat.
Once at the hospital, did firefighter McLaughlin go into the hospital with the other firefighters?
I believe so, yes.
So she was with you in the engine. She was, although in the driving cab, she was with you, ambulance in the driving cab. She was also with you right after the scene at the hospital, correct?
Yes, sir.
And she was also with you later after you cleared the hospital and went back to the station.
Yes, sir.
Oh, sorry.
You had discussions with firefighter Flamati about the incident. That would be normal protocol.
Correct.
Almost like a debrief.
Sure.
You had the same types of discussions with firefighter Kelly, Matt Kelly.
Yes, sir.
I'm guessing that you probably had the same sorts of discussions with firefighter Walsh.
I actually don't know if I saw firefighter Walsh when we got back. The weather was right at shift change, and the weather getting back was also getting worse. So I honestly couldn't speak to that.
And you also had conversations with firefighter McLaughlin after you cleared the hospital and got back to the station as well.
She was part of the debrief. Yes, sir.
Okay. And all of you discussed what you did, saw, and heard, generally speaking, while at the scene, correct?
Those are more in terms of getting equipment wrangled, really kind of how they go. What did we use? What do we need? What are we going to have to restock when we get back?
Right. But there also was obviously discussions about what had just happened. I mean, you were dealing with a dead or dying police officer on a lawn, on a snow-covered lawn in a cold environment.
I honestly couldn't speak to that, sir. I honestly don't remember.
It's because you don't remember, correct?
Well, like I said, it's mostly those debriefs are usually, they're very
Here we got a bad link
Equipment.
there.
Make sure that the ambulance is ready for the next call, etc. I'm asking about a general debrief with the fellow firefighters, male and female, that you were with at that scene. You're telling me that you don't remember debriefing and discussing the incident and your observations at the incident following that incident.
No, sir.
Okay. But your memory, you indicated earlier, gets better with time, right?
Yes, sir.
You don't remember it as you sit here today?
Ask the question again.
Sure. Do you remember discussing with firefighter Flamati, firefighter Walsh, firefighter Kelly, firefighter McLaughlin, any of them, your observations and what happened while at the scene after you cleared the hospital and got back to the station?
No, sir.
Have no memory of that whatsoever.
No, sir.
When we left off before lunch, I was asking you about a hematoma and a laceration over the right eye of Mr. O'Keefe. Do you recall that?
Yes, sir.
I asked you, is being punched in the face, can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it.
You answer that question?
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from numerous
Yeah, you can't admit it, can you?
ways.
And
Oh.
Yes, it could be from that. It could be from others as well.
Okay. So that's
Oh,
what I'm
okay.
asking.
Got to make sure
It
you.
could be. In other words, it's consistent
Yes,
with
sir.
being punched in the face, correct? Correct. Thank you.
Way to go. Hey, Jake, press him on that. Way to go.
I want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
Yeah. All right, we got it.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask, delivering ventilations. Firefighter Kelly was to the right, and firefighter Flamati was on the left side of Mr. O'Keefe, and the three of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but
Nope.
you'll correct me.
Yes, sir.
Yeah,
Your
know how
job
many
was to
sirens
do
you
the
hear?
airway, correct?
Yes, sir.
Unbelievable.
I'm picturing a big balloon-like apparatus that you put over the patient's mouth. And
Exactly.
Squeeze it.
Yes,
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
correct. Yeah,
You were the airway person doing the squeezing of the bag.
correct.
What was Tony Flamati, firefighter Flamati, doing?
He was starting CPR, and which that point was taken over by firefighter Kelly.
Okay, so firefighter Flamati, when you say starting CPR, describe what that means. What is the physical act of CPR?
So you put both hands together like this, one on top of the other. You put it right on top of the sternum, and you begin doing chest compressions 2 inches deep, allowing full recoil for 100 to 120 beats per minute, compressions a minute to sustain a cardiac rhythm. You're manually making the heart beat with each compression.
Which means that is a rhythmic pumping motion, correct?
Yes, sir.
So if you see someone doing CPR, you're probably going to see their shoulders moving up and down and moving rhythmically, correct?
Correct.
Do you remember what firefighter Flamati was wearing? You had just come off of actually you were just coming onto a shift, so you didn't have all your foul weather gear officially, correct?
I had my puffy jacket.
Okay.
I had my Canton Fire jacket.
Got it. Firefighter Flamati, on the other hand, had a bright yellow jacket,
Correct.
sort of reflective, and a safety jacket.
Yes, sir.
And he was kneeling to your left at the time doing, have I got that right?
Yep. Nope. Yep. You got that right.
Okay, he's kneeling to your left at the time doing chest compressions. That's when you indicate that Miss Reed walked over and made the statement.
Correct.
And Kelly was there as well?
Yes, sir.
Kneeling
But you
right
were going to pay
beside
attention to
all
somebody
three of
that's
you
lounging
as
around there
Firefighter
Not
Flamati
lounging,
was
but
giving the
being-
chest compressions, correct?
Yes, sir.
in your way, in essence?
You indicated that the statement was in response to a question that you asked of my client, do you know him?
Yes, sir.
Is that right?
Correct.
And she responded
Why
to
would
you
you
with
ask
the
that?
phrase that you've used. I hit him.
I hit him. I hit him. I hit him.
Right. So it's absolutely clear in your mind when that statement was made. You were knelt down over Mr. O'Keefe. Firefighter Flamati was doing the CPR, and Kelly was with the both of you when you posed that question.
Yes, sir.
It's a very detailed memory.
Yes, sir.
You indicated, Mr. Brennan, that sticks out in your mind. Is that right?
Does.
But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time.
I don't recall that meeting.
Okay.
I recall meeting with him, but I don't recall the extent of what was discussed.
You literally don't in that meeting in that formal interview with the lead detective on this case.
We discussed the case, but I don't, and in his words, I'm not sure what he put down.
What you said to Trooper Proctor on February 8th, 10 days after this, was you overheard Miss Reed say, I hit him one time to another female that she was talking to, correct?
Objection.
No, I'll allow it. Did you say that?
I have no memory of this, Your Honor.
Okay, next question.
Wow.
Did you say that her statement was an answer to a question posed by the female or a discussion with the female?
Break that down for me, sir.
Sure. Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
Did you tell Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Miss Reed was actually praying over John, your words, praying over John?
Look, yeah,
I
surprised.
don't recall ever saying that.
Voice is memory bad.
May I have just a moment, Your Honor?
Yes.
This is your first witness, Brennan? Wow.
Did you say that you observed Karen Reed to have blood on her face from providing mouth-to-mouth breaths to Mr. O'Keefe prior to your arrival?
I remember Miss Reed having blood on her face, presumably from attempting CPR.
Do you remember telling Trooper Proctor on February 8th that you saw her with blood on her face from CPR?
I do.
So you remember
you
that
remember that.
portion of your conversation with Trooper Proctor, correct?
Yes, sir.
But the praying over the victim, you don't remember.
I don't remember ever saying that,
And
ever.
And the statement, I hit him to another female, you also don't remember that.
No, sir.
Would it refresh your recollection if you were to look at a report
Yes, sir.
offered by Trooper Proctor? May I?
Yes.
Very rarely does she stay overruled. I think we heard it just a sustained defense objection one time here. This
May I direct
Morning
your
with this
witness's attention
witness.
to the second page, Your Honor?
All right, why don't you take a look at that?
see, helpful stuff from Karen, he doesn't remember, but he's got such a laser
May I approach
focused
your Honor,
memory
please?
on what she said. He earlier said he didn't even ask a question. She was talking to somebody else.
The report that you were just shown,
Yes, sir.
does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case.
I have no recollection
Look at
of
that.
ever saying that anybody prayed over anybody ever in this case.
You did see it in his report, though.
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
In your April 2024, it's April 30th, 2024 testimony from last year.
That's what it comes down to.
You were asked whether or not your memory was a little faulty, and your answer was absolutely, correct?
Could I have a page and number,
Where is
please?
that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16.
Can you read the lines again?
Lines 14 through 16. I'll just allow counsel to get that up.
If we could pose the entire question and give content to it, please.
So it looks like this guy's intentionally trying to keep his eyes open and not close them by having his
May I?
foreheads.
Yeah, so do you intend to show the whole question?
The
Crunched.
whole question that I asked and his answer, yes.
All right, and I'll give you the opportunity. I'll redirect Mr. Brennan if it's not. Go ahead.
Is it true that in answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame? Your answer was absolutely. Correct?
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here,
I think he did say that.
your
I don't
memory
think
is
Proctor was
still
making that up.
faulty about your conversation with him.
With
Correct?
Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay, next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over John O'Keefe.
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
Now, he said that multiple times.
My
so-
point is, if you have no recollection of it, you're not denying saying it.
Objection.
Are you denying saying it?
Yes.
So you do have a recollection that you never said it. Did you understand the difference?
Oh, sir, I don't believe I've ever said praying. That's really not something that I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed
You didn't
in regards
see
to
it
this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor,
The report that Trooper Proctor wrote?
correct?
Again, I don't remember ever saying the words praying
Selective
over him.
memory.
I do distinctly remember I hit him, I hit him, I hit him.
Can't
Which
trust
doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. I'd like to show you a short portion of a video, the same video that you were asked to look at on direct examination. And Your Honor, I pray to the court, I can certainly mark it as a defense exhibit or for
So is this
identification.
going to be an exhibit by agreement?
It cuts them
It
off.
is.
It
Never
is.
does
So
that
we now that,
prosecution.
Madam Court Reporter, thank you.
Clear bias.
Exhibit 4, so much.
Thank you, Your Honor. With the court's permission, may I play a portion of that video for the jurors, publish it?
Okay. Which portion so people know?
I'm going to start it at about, I want to say 6:55. Mr. Walt, could cue that up? Before you play it, can we have it on that screen as well, or is it only playing to this screen?
I don't know.
He
Unless
loves
Gilman
cutting
did
off
it
the
was fine.
defense.
Great.
There we go. All right. Before we play it, can I ask you a quick question about this?
Sure.
It appears that this is paused. Do you recognize this as being the same video that you were shown this morning by Mr. Brennan?
I do.
All right. Describe the scene.
So that is 34 Fairview Road. The lights in the background, I believe it is either right as we pulled up or right as we're pulling up.
Okay. Same dash cam video.
Yes, sir.
Can we scroll this to the 6:55 runtime spot, please? Pause it. Okay. Do you see the individual on the left? Far, far, far left.
Yeah, the jacket?
Correct.
Yes, sir.
Who's that?
I believe that's firefighter Flamati.
You previously indicated
All right.
that firefighter Flamati was on his knees providing CPR at the same time you were knelt down providing the airway.
This isn't when it was
That's
stated.
not my question. Is that what you said?
Can you repeat the question, please?
Sure. You indicated earlier when you heard this statement by my client, you were very detailed. Firefighter Flamati was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a
firefighter
yes or no
Flamati
question.
had
Objection.
So I'm going to let the witness answer the question.
transferred CPR to firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Okay.
My question is an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement that firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay. Firefighter Flamati, in your testimony, appears to be standing up right there, correct?
Yes, sir.
Let's play the video forward for just a second. Stop it. What did you see firefighter Flamati do just now?
I believe he just knelt down.
Okay. So at this point, He's kneeling for the first time, correct?
Yes, sir.
And he's about to provide chest compressions as your memory serves, correct?
Yes, sir.
All right, let's go ahead and play it forward. Pause. Did you see my client in that photo? I'm sorry, in that clip?
No, sir.
You didn't see her?
Oh, no, I did see her. Yeah. I don't see her on right now.
Right. She just walked off frame, correct?
Yes, sir.
Let's go ahead and play it forward. Stop it. You see my client walk back into the frame?
Yes, sir.
At this point, you were watching firefighter Flamati. He appears to be now providing CPR, correct?
Yes, yes, sir.
Okay. And my client is nowhere near you, correct? At least for this clip.
No, sir.
Okay.
Correct.
And the clip that I just played before, the few seconds that I played before, nowhere near you, correct? Is that right?
Yes, sir.
Let's go ahead and play it forward.
All right, where's the ambulance here? You think the ambulance should be there by now?
Pause it.
If you're busy trying to save the
What do
life of
see
a guy
happening
you
on
said
the screen
basically
from
didn't have any
screen right to
pulse,
screen left at this juncture?
We're
oh,
bringing in the
pay
stretcher.
attention,
Okay,
anything, and
go ahead and
say,
play.
ask somebody, do you know this guy?
Pause it.
This is insane to
Do you
think
see where my
that.
client is right now?
That would really happen.
Seconds. Sorry, I lost
With the
view.
court's permission, I need to ask the court's permission. Thank you. Okay, let's go ahead and play it. Pause. Did you see my client?
Yes, sir.
Where is she in the frame?
Behind that other individual.
Behind the SUV?
I believe she's in front of the SUV and behind the other individual.
Okay. I'm at the SUV, that's the white SUV that's in
Yes, sir.
the far distance.
Yes.
That's the back of the SUV. She's behind it, right?
Correct. Yes.
Yeah, it's
Not
Jen's
near you.
SUV.
No.
Okay. Let's go ahead and play it. Go ahead and pause it. Do you see what firefighter Flamati is? Entire clip.
Chest compressions?
Okay, let's go ahead and play it. Pause. What's happening now?
Where Mr. O'Keefe's on the scoop stretcher and he's being transferred to the ambulance stretcher.
So that's the entire time Mr. Flamati, firefighter Flamati, was giving chest compressions. It's captured right here on this video, correct?
Yes, sir.
Okay. And now Mr. O'Keefe is up on the stretcher.
Yeah, good point, RN.
And
You can't remember what John's wearing.
down.
No, sir.
And
Doesn't mention
firefighter
till
Flamati is
later.
no longer knelt down.
No, sir.
And you're now following the stretcher with, it looks like 2 or 3 other EMTs, correct?
I am not in that frame, sir.
Okay, so you've walked away.
Yes, sir.
All right. Let's go ahead and play it forward. Pause it. You see where my client is?
Yes, sir.
Go ahead and play it. Do you see firefighter Flamati or firefighter Kelly?
Jen
continuing
looks
to give
stressed
chest
out.
Compressions?
Yes, sir.
I mean,
Which
Karen
one is
does,
that?
Jen
I
doesn't.
believe it's firefighter Flamati.
Flamati?
Believe so.
Okay, so he's still doing
in
all
there
the
and
chest compressions
put it
from
in
start
parka.
to finish.
Yes, sir.
Okay. And what's happening right now?
Now we are transferring to ambulance 1.
She's looking John as he's going by.
Right front and center.
May I have just a moment, Your Honor?
Yes.
They need to focus on Jen's behavior in this coming trial with these witnesses. It's really revealing.
If I may have just a second.
So they're going to try to kill John O'Keefe and then come around and say, I did it. That makes no sense. How you go from an intent to kill to an intent to right away confess, I did it, and
With
then
regard,
you
just a
act all
couple more questions
concerned.
with the court's permission. I'm going to change
That he may
gears.
die.
With regard to what you talked about on direct examination, the hypothermic conditions, you're not a medical doctor, correct?
No, sir.
You don't diagnose patients?
Sir.
You're not diagnosing that John O'Keefe suffered from hypothermia that night?
No, sir.
Thank you. That's all I have.
Any follow-up, Brennan?
Please.
Okay. Witness one destroyed by the defense. Let's see what Brennan does for
Firefighter Nuttall,
trying to rehab him.
the video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were two different time frames on that video.
And when we spoke about when the defendant
Now
said
he's
to you,
mad
I
and
hit him, I
pointing.
hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from and when you first went over to John O'Keefe?
Sure.
With the court's permission, Ms. Gilman, if you could start that video, I think it is 6:11, please.
The grating voice is
Now
back
stop it
alive.
there. Do you see that this exhibit has timestamp on the top?
Yes, sir.
Okay. Please continue.
Yeah, I always say that. Never call him your client. No matter what video they show, how Karen is close to him and John, it doesn't matter. It's not believable. He's going to start questioning Karen. Does she know him? Do you know him?
Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrived and walk over to help John O'Keefe?
Yes, sir. That's me.
I'll note that the timestamp is 6:11:21. Okay, continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Was any of this shown to you during those questions?
No, sir.
No. Continue, please.
Yeah, it's Karen. All upset, unlike the other two ladies there.
Stop, please. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained is to the form.
Okay, what direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay, please continue. Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
I do.
Okay. I'm done with the tape. Thank you very much. Now, you were asked questions about your memory.
Yes, sir.
Okay. When you were asked the questions about Trooper Proctor, when you were saying that you didn't remember, were you referring to the conversation with Trooper Proctor Or were you suggesting you didn't remember what happened that morning?
I don't remember the interview with Trooper Proctor. I remember it happened. I don't remember the substance of what was discussed entirely. I remember we discussed that morning, but.
Do you know if that conversation was recorded or just a conversation between you and the trooper?
I do not know if it was recorded.
You asked questions. I want to ask you about questions on Mr. O'Keefe, and you mentioned that there was some type of blood clotting on the back of his head.
Yes, sir.
Okay. You noticed there were abrasions on his right arm.
Yes, sir.
You noticed there was a hematoma on the right side of his head.
Yes, sir.
Did you see any bruising on his right knee?
Don't recall, sir.
Did it stand out to you that all of his injuries, all of them that you saw, other than the cut on the back of the head, that they were all on his right side?
Yes, sir.
Did you notice any hematomas on his left side?
I did not.
Did you notice any scratches or abrasions on his left side?
I did not.
Did you notice any marks that would be consistent with an altercation on the
personality
left
is really-
side of his body?
I did not.
You were asked about the cause. And you
Angry
said that you
type.
don't know the cause. You weren't there, were you?
No,
Keep
sir.
it up,
You asked
Brennan.
if it was consistent with being punched, and you said it could be.
Yes, sir.
Could it be consistent with being clipped by a car?
Objection.
Sustained as to the form.
Oh, she's telling him how to fix
You
it.
were asked questions about clothing,
Yes, sir.
and you had at one point said you thought that Mr. O'Keefe was wearing a winter jacket. Do you have any memory that when you first got there, or when you first got there, do you have any memory whether there were any towels wrapped around Mr. O'Keefe's head?
I remember there was a white cloth of some sort on the scene.
Okay. And when you were asked about your memory regarding the clothing, was the clothing of what was utmost importance to you at that time?
No, sir.
And why is that?
I was, again, focused on Mr. O'Keefe's airway and ventilation.
No, you weren't. You're trying to ask questions of Karen.
And when you were asked about the clothing, do you remember if you added anything else about your certainty or uncertainty about clothing when you previously gave a statement or testimony?
I believe when I testified last year, I did note I had no part in removing any articles of clothing or anything like that. That was not my job in the back of the truck.
Do you remember any recognition of the fact whether you were certain or not about clothing?
Repeat the question, sir. I'm sorry.
Well, is there anything that would refresh your memory about what you had said about clothing?
Objection.
Ask a different question first.
You had mentioned that you had some difficulty about clothing. Do you remember what you had previously said?
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold.
Sure.
They were difficult to manipulate. Just they really was not conducive to getting clothing off easily.
Okay. You met with me 3 times.
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter? There is no side. Doesn't matter if it helps or hurts, that you just tell the truth?
Sustained.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest to you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
Objection.
I'll allow it.
Yes, sir. 3 times.
And in fact, do you remember, in addition to her saying, I hit him, I hit him, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
I do not.
He sounded angry.
The answer is I do not. Next question.
He's mad.
Okay.
It's not likable. He doesn't have a likability factor. That's what I'm saying here. Yeah, he's not coming across well at all. Angry prosecutor.
Do you remember testifying previously in this case?
Yes, sir.
There's a nasty tone. And even if she did say, I hit him, yeah, she's feeling guilt or something. It doesn't mean she actually did.
Do you remember at all discussing whether or not, after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember after the defendant left you and made that statement to you, do you remember talking, did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Brennan.
And when she said it to,
Stating the objection.
when she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry. Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
Yeah, we see a whole different personality now. The real angry side of Hank Brennan's coming out, and he is angry at the points that the defense made about this guy. He's angry that he's looking so terrible, and this is his first witness. This is what you're hired to do, is get a conviction. This guy's not helping you get there. You really think what Karen Reed said there when she was still basically under the influence of alcohol, some from that hours of drinking the night, many hours before that, she's still feeling the effects of it. She's upset. It's cold. And this guy's trying to bring somebody back to life, and he's paying attention to who's around him and trying to start up a conversation with her. It's just really ridiculous. And if she says, I hit him with, well, he didn't say ask with what or anything. So what, with a fist or something? I mean, come on. Yeah, it's not a confession. Oh my gosh, I hit him. Could have been a question mark. So, or it could have been a statement. I hit him. Did she make a statement? I hit him, like she's gloating over it. Hey, I hit him. It worked. Me spinning it in reverse, and I was able to hit him. She's not saying this like she's proud of it, like she accomplished something. It's just this whole witness is nothing but bringing down the prosecution. It just shows their desperation. Yes, this witness is very uncomfortable. Any jurors wondering why did I agree to sign up for this? Yeah, the body language speaks volumes. Does seem like Jen planted the idea in the car. Now Karen is hysterical and could say anything. This is just really, I don't need defense need to spend that much time on this. He's pretty much done his damage. He's actually helpful to defense.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her
Closing
making
his
further
eyes.
statements similar
I do.
to the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
Now he's come up with more. More times she said it. Before it went from 2 to 3, now it's multiple more times. What's going on here?
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times, correct?
I remember hearing it in the background several other times.
Really?
Sir,
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You're
You
right
were
about it.
asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
Well,
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the background
Right?
as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background,
In the background.
as you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase,
Mhm.
in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. It's why you're here.
Again, if it was neglected on my part, it was
2
not
to 3 to
intentional.
not
10.
intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on on recross examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes,
And
sir.
it was after, of course.
He became a little
your new
detective mode
statement
there.
that you've never testified to before, ever, is this generalized commotion included a bunch of I hit hims in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you described having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me,
Yes.
that was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
Alan
He was doing
Jackson,
CPR
tone,
down prior
booming
to that as
voice.
well.
Great to see
Really?
that.
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR. We just watched that video, correct?
But again, the clip of the video that you showed me,
Right?
that was not the segment in which he said that to me.
Well, that's what you're saying now, but what I'm asking is, you described a very distinctive scene, a very, very specific scene.
Yes, sir. I remember it vividly.
She said that I hit him phrase when Flamati was down giving CPR and you were kneeling down giving airway support and he was doing rhythmic CPR chest compression.
Yes, sir. That's what happened.
And then I showed you that very scene, didn't I?
Yes, you showed me that clip prior to that.
I showed you the very scene that you described where Flamati gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the Isn't that what I showed you?
That is
Sure. I don't know if I can do it again. I showed you the scene where firefighter Flamati gets down on his knees, begins chest compressions, and never stops until that gurney is taken off
It
camera,
gets better over
off
time.
frame, into the ambulance.
That is-
That's the clip I showed you, correct?
that is the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said, I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the three of us were together.
So Flamati was not giving stress compressions then?
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Officer, Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point, at that time or after, did my client even approach you, did she, in that clip?
She did.
What?
Objection.
Just a question.
Sure. Do you need to see that clip again?
Yes, please.
We're not going to show the video again. We've seen 2 videos. Which one is marked?
The
The
Commonwealth.
one with the timestamp at
Right.
the top?
It's the exact same video. One has timestamp, one doesn't. Just to be clear, you described a very detailed scene in which firefighter Flamati got down on the ground on his knees and began CPR.
Yes, sir.
We saw a clip that it played fully through.
Mhm.
Starts and stops, but it played fully through, correct?
Yes, sir.
That was true.
How wrong of the judge not to allow that
What
to be
happened
shown?
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped.
Now I have to describe it instead of just showing it. This judge,
Correct.
I'll tell you.
You also described very clearly before you saw the video that the time when my client walked over and you had this dialogue and you heard this statement,
Mhm.
it was during the time that firefighter Flamati is given CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she? In
She-
that-
She did in the video.
In the portion that Mr.
Judge is
Brennan
rotating her
played you,
chair.
was firefighter Flamati giving CPR at that point?
As I said previously,
She's
Was he
not
or
doing
was
that
he
when the
not?
prosecution's
Yes or no?
asking questions. She's trying to
Objection.
signal
I'm
the
going
jury,
with
don't
witness
listen to
answer
this
the
line of questioning. That's what it comes across as.
firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to move towards firefighter Kelly performing CPR because at that time his skill set was not as advanced as
Right.
firefighter Flamati's, as Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
But the video that Mr. Brennan showed you was earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right, he hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can.
Oh,
Give you a couple more
my
minutes.
gosh.
Do you understand the confusion?
Objection.
Sustained.
All right.
This guy is
couple more
very
questions on
confusing.
this.
I think you made your point, AJ. This guy's all over the place.
The
Can't trust
video-
a word he says.
That Mr. Brennan showed you,
Yes, sir.
and you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati
I don't think the
was
jury's
not
confused that this guy's
even
confused, doesn't know what he's
kneeling
talking
down
about.
giving CPR, was he at that point?
No,
The answer is yes or no?
No.
Okay, he was not.
believe a
Later,
word
as
he
as the video continues to run, at some point, we see firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near you. Isn't that what the video showed?
That was the segment that you showed me.
You indicated on redirect, that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true that in addition to the egg on the right side of his head, he also had a black eye on the left
That's
side?
what I said.
I remember that the swelling had
Judge
started
can't hate you any worse.
it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you
Or
remember
battle
saying-
signs.
Do you remember saying, in answer to the question, did it look like, in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over
She never
time.
tells the prosecutor, you need to wrap it
both
up.
sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
Yes, sir.
Let me ask you the question
An
again.
injury left side of his,
Did he
side
have
of
an
his
injury
brain.
to the left side of his face?
Yes, sir.
Thank you.
There's more that they talked about from his body language, him and Brennan, that he's not sharing here. You think back to his original statements when he's blinking his eyes and squinting his eyes tightly shut when Jackson's asking him questions.
One last question. You indicated
He's
that
not
it was
coming
a
clean.
chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights.
He needs to be aggressive like this. Every defense attorney needs to be aggressive, heavy hitting, loud at appropriate times,
Don't recall.
and make these witnesses know that
I have no.
they're calling them
idea
out
who
on their
the
lives.
homeowner
They're not
is.
going to get away with lying in the corner and not have somebody get in their face.
No, sir.
That's all I have.
One issue. Briefly.
Here goes Brennan again. I mean, he's just going to want to go forth and back. Then she'll cut off the defense. I think she's calling him up there to say, we can't have this ping pong match going on, this volley going forth and back. Because Brennan always has to get the last word in. He always has to get the last word in, I think. My read on his personality is he's just seething right now. He wants to get the last word in. He wants to get basically this witness rehabbed as much as he can, which he can't, because he just wound up having to blow up in his face because he went from 2 to 3 to many more. And so he's not happy with this. And the judge, I think, realizes, like, wait a minute, if I allow Brennan to go again, then the defense is going to go again. Then Brennan's going to want to go again. So when am I going to call an end to this? He's already completely come across as a person that you cannot believe a word they say. And so really, this is taking up more court resource time to have Brennan just not get off this thing. He needs to move on to his next witness because he's not going to rehab this guy. So hopefully he won't have any more here. Just maybe 2 or 3 questions or no questions would be better. No, it looks like he's going back for a couple questions. I promise, Judge, just a couple questions.
Sir, in Mr. Jackson's questions, he asked if you had ever said that you heard the defendant say, I hit him, separate from when she approached you. Do you remember previously testifying that you heard her saying, I hit him in the background, separately from you?
Yes, sir.
You remember testifying that before under oath
Yes, sir.
in court?
I do.
Anything, Mr. Jackson?
Yeah, just a second, Your Honor.
Just a couple questions. All right. Is that true? Defense is going to try to say when and where. So if he's testified that previously, how to go from 2 to 3? Didn't go to 3 last time, so it went from 2 to also background chatter multiple times being heard. I hit him, I hit him, I hit him, I hit him. Either way, it doesn't make any sense for Brennan. He's fighting a losing battle. This guy's toast. Yeah, he knows he's flailing. Total trash witness. Trash testimony.
Thank you, Your Honor. If I may.
Yes.
Just a quick question, Firefighter Nuttall. When you were asked to recite your memory of that day on February 8th, 2022, just 10 days after this incident, did you ever say that you heard in the background, I hit him over and over again?
I don't recall.
All right.
When you testified at the grand jury, last question, when you testified at the grand jury, did you ever say that?
I don't recall.
But again, your memory is better now.
And now he recalls it because Brennan told him, isn't it true
Yes,
you said it outside in prior testimony?
Thank you, ma'am.
All right, your
But
next
Brennan never
witness,
said when
Mr.
he said
Brennan.
it.
Thank you. The
It
Commonwealth
looks like he just
calls
made it up.
Kerry Roberts.
Chrissy, could I have anything?
Yeah, that guy, wow. Unbelievable to have a guy like that as your
In the
first
stand, I
witness.
did have an exhibit I would like to introduce and
Okay.
play for the jury.
Really cringeworthy.
And this is clip 2.
No objection from the defense?
No, Your Honor.
Here's Carrie Roberts. Keep in mind, she's talking about John O'Keefe as a
And you're marking
friend.
this as an exhibit?
Yes, Your Honor.
Okay. Do you have something for the court reporter to mark?
That's what we're going to try to do. Between each witness, maybe put in another statement of Karen. So it has to be an issue of only what Karen said, not about what the evidence shows outside
So
of
we
Karen's own
need a-
words.
We need something. So we need something physical. You can play it and then we'll mark it.
Ms. Gilman, do you have a separate clip?
Jim, is that right?
Thank you. I can have this marked, Your Honor.
Thank you. All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms.
Oh,
Roberts.
okay, I'm sorry.
Thank you, Your Honor.
Every day they come back to you and stuff like me. How much do you remember?
I remember it, but I questioned do I remember it because it's been relived so much. I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that. So the closest I must have said was, did I hit him? And I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I now call Kerry Roberts.
Yeah. I'm sure if she said that, that's not something that's incriminating. You got to have physical evidence to back it up. They don't have physical evidence to back it up. Forensic physical evidence. So Jen made her feel bad, like she went back there and didn't recall that she went back 34 Fairview. So that's a normal question to ask. Well, did I do something? Was I part of this? But that's not
All right,
incriminating.
Mr. Brennan, whenever you're ready.
Thank
Your
you, Your Honor.
convictions is
Good afternoon, ma'am.
based on that, you're
Could
going
you
to lose.
please introduce yourself to this jury?
Hi, my name is Carrie Roberts.
Ms. Roberts,
Well, that
where
Jen
do you
says her
live?
can't keep her
I
mouth
live in
shut.
Canton, Massachusetts.
She runs her mouth
How
all
long
the
have you lived
time.
in the area for?
Yet they're friends.
I was raised in the Boston area, North Shore, South Shore. I went to high school in Braintree and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
How old are your children presently, this day?
My son is 13, my daughter's 15.
Who cares their
Do
age?
you work?
Yes, I do.
Without identifying specifically where, can you share with us a little bit about what you do?
I'm an executive assistant and I've been with my company for 18 years.
Ma'am, if you could just move the microphone just a tiny bit closer. Thank you very much. You have 2 children, you're
Yes.
married,
Yes,
and you live in the area.
yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Would you be willing to share with
That's
us
what
when you
Jen
first met
texted.
Mr. O'Keefe?
Well, I went to high school with John in Braintree. He played soccer, I played soccer, so we probably hung out in middle school, but we went to 2 different middle schools. And then I hung out with him more in high school. He was a year older than me. His sister was 2 years older than him in school, and his brother was younger. So at some point, I was in high school with each of his siblings.
Notice the
Did you at
judge
some
isn't
point
rotating in her
become
chair anymore.
Friendly with John O'Keefe.
Yes.
Could you tell us about that?
When his sister Kristen passed away, and then her husband Steve passed away, they lived in my neighborhood. John took over for the children and moved into my neighborhood as well.
When John took in the children, did you offer any assistance or any help to him?
Yes, before John was even going to take over, he was going to potentially move in with his brother-in-law and the children to help out. And then when his brother-in-law passed away unexpectedly, John took over and I jumped in because I was a friend from high school that he knew and he had all kinds of people helping, but he sort of said, I'm going to lean on you for right now because I know you best. And I knew his parents and his siblings. And so I introduced him to my husband and we jumped in. It was, preschool drop-offs, preschool pickups for my son and his son. And just from then until the time of his death, we were just friends, very close friends. And we hung out all the time. The children hung out all the time. And he was the emergency contact list at my children's school to call if something had happened.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
You mentioned you have a son,
Yes, I do.
and is your son the same age as John's nephew?
Yes.
Was there any common interests or activities that engaged your son with John's nephew?
Well, they went to in-home daycare together. They went to preschool together. They went to pre-K together. Then they went to elementary school. They played baseball together since they were T-ball. My son plays hockey. Patrick tried hockey. He didn't like that. So we spent a lot of time at the baseball fields together.
As you spent a lot of time together and had mutual care of children, did your relationship with him grow closer?
Yes.
And can you share a little bit with the jury how close you became?
Well, John was a bachelor and he didn't have any children of his own. So when he took over for the children, he sort of, leaned on us to kind of guide him and, all the things to do if there's someone has a headache and, if there's an ear infection or, he had his mom and dad also helping as well, but I was right up the street. So if I would go to BJ's, I would call and say, can I grab you anything? If I would go to Walmart, any of the places I would go, I would call and say, do you need anything? Can I help you? Can I grab something for you? And he did the same. We just sort of all chipped in and helped.
As your friendship grew. Could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
Tell us about the day-to-day activities and
Seems
how you
strange.
try to assist John with the children.
Well, John moved across town. I don't remember when. I forget how many. Patrick, I think, was in 5th grade or 4th grade. And I would take him home with me on Wednesdays because John would be working. So it was more of a, if he was at my house and my daughter needed a ride the other side of town, he would take her with him. We were just very close friends. We did a lot together. We would do baseball tournaments together. We would have drinks together. We would, all the things friends do.
As you grew closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul, I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Can you tell us a little more about the collective effort of other people, including his family, helping John raise these children?
There was a lot of us that jumped in to help. It was not just me. There was a lot of Kaylee's friends' parents that jumped in and helped out for Kaylee, his niece, and Patrick. There was a lot of us that helped out with Patrick. All of the community all came together to help him because there was this guy that just lost his sister and brother-in-law, and he stepped in to take care of his 2 kids, and he didn't really know what he was doing at first, but he got the hang of it pretty quickly.
So
You have a
is
son
there
that
to
shared
help
a lot of
kids or
interests with his
interested in
nephew.
John, or which
Yes.
was it?
He also had a niece.
Yes,
Did you spend more time helping with his nephew or with his niece?
with his nephew.
Were there other people in the community you
Yeah.
knew of who spent more time helping with his niece?
Yes,
And who was that?
Jen McCabe.
Yeah, really
Did you know
strange.
Jen McCabe?
I had met her once. John got a discount at Reebok, so he would take the kids.
They
Well,
openly
he would
say
take
it.
anyone
too.
with kids up with him to get shoes, like sneakers for back to school or whatever. So
I mean, it sounds like she's like his girlfriend.
Take Jen and I up to Reebok, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
Yeah, Jen calls her the
As it
talker.
relates to the night of January 29, 2022, how much earlier was it that John took you out with the children and Miss McCabe out with her children to get sneakers? How many years before that?
Years, like 6 or 7 maybe.
And from that time you met Jen McCabe in the years past, did you ever spend time with her again before January 29th, 2022?
No, I did not. I didn't know her.
I wonder
Were
if
you
she
friends
gets
with
a
her?
lot being
Did you speak on the phone with her?
having
No, I
love
did
for
not.
John
So other
too,
than
like
that
Jen
one
did on
meeting-
her direct.
You were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become familiar or know about Miss Reed?
July, I think it was, of 2020. John, we were having people over, and so I invited him, and he said, I'm going to bring Karen over. And I was like, I don't know who that is, but okay. He assumed I knew because he had been dating her for a little bit, but it was COVID, so we didn't see him very often during that time. So Karen came over that night.
And this is early 2020?
I think it was summer, so I think it was around June or July.
Briefly,
she
just
did.
tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house and we hung out on the back porch, had some drinks, there was music, kids were around, just a nice, normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes,
Did you see her more often?
yes.
And could you generally describe to the jury how you learned more of her and saw her more often?
She would take care of the kids a lot. Mainly, well, not mainly Patrick, but not mainly Kaylee either. She helped out a lot with the kids. So if we were at baseball, she would come to all the baseball games, or she would drop off or pick up my son or Patrick if they were going to the golf course or the driving range.
Would you see her during events with your son and John's nephew?
Yes, we did baseball tournaments and
So when you go to
Kinda
baseball tournaments,
humanized,
would that be
yeah.
away, an overnight type trip?
What some of this is going to
one
be
of them
about.
was down the Cape.
How often would you spend time with John and the defendant?
Not that often together, but John would stop by himself. My husband would go out more with John, but I didn't spend much time with the two, not a lot of time outside of the baseball field.
Did you become friends with the defendant?
We were friendly.
Did you ever spend time alone to go out or socialize?
I did not.
Would you see her when you would pick up or drop off kids, or she would pick up or drop off kids?
Yes.
Did you ever speak to her on the phone?
Yes.
In relation to what?
Corresponding with the kids, pick up, drop off, mainly Ryan and Patrick, not about Kaylee.
Did you ever spend any important dates or times or holidays with John and Miss Reed?
No.
I want you to take us ahead to January 28th, 2022.
Okay.
On January 28th, 2022, do you remember that day?
Yes.
Generally, what do you remember about the day of January 28th, 2022?
There was a blizzard coming, and it was my daughter's friend's birthday. So we were going to be going out celebrating that night, but we did it on the early side because there was a blizzard coming.
What was your plan for that evening?
We went bowling. We got dinner, then we went bowling, and then I came home because I wanted to be in before the snow started.
Had you communicated in any way with John that day?
Yes, he texted me. My son had had an issue at school. Patrick had been dismissed, I think, for a doctor's appointment. So he did text me to see how my son was doing.
All right. Too much for kids. Come on.
Did you get a chance to speak to him that day?
I believe we just texted.
Did you go out that night after bowling?
No, I did not.
Was your husband home?
Yes,
Did he go out that night?
he did. He went out with John.
And do you know where he was planning on going?
They went to McCarthy's, a bar in
Looks
Canton
like she has a
Center.
judicial
Have you
robe
been to
on.
McCarthy's before?
Yes.
Can you just briefly
I
describe?
didn't see what she's wearing, but it looks like she's got a
It's
robe
a
on, like a
restaurant bar.
judge.
There's a large bar in the middle, the seating on the left and the right. It's right in the center of town.
Do you remember about what time your husband went out?
I do not remember exactly. I don't know if I got home and then he went out, or if he was already gone when I got home. I don't remember, but it was he went out around the same time that I arrived home, which was on the earlier side.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many,
Many times?
many
Were
times.
you familiar with the house and the driveway?
Yes.
May I approach you on?
Yes.
Should I return to the podium and ask the questions?
You
John?
can ask them from there.
Thank you. Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
I'd like to move this to evidence, please.
Okay, any objection?
No objection.
6-6.
May I publish to the jury, Your Honor?
Yes.
Thank you. Thank you. You can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how John's driveway appears?
Yes, it is.
I'd move that into evidence.
No objection.
Okay.
Exhibit 7 so marked.
Not being introduced through law enforcement,
Yeah,
taking
yes.
photographs of the scene.
Could-
We don't have a photograph of John O'Keefe laying there. And he was even a law enforcement officer. They didn't even bother to take a
I'm showing you a
photograph.
third photo. Do you recognize what's in that photo?
Yes,
And could you share with the jury what's in that photo?
it's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights. Or the Ring camera.
Are you guessing, or do you know that's a?
No, I know there's one there
And how do you know that?
because I got a Ring camera and I could look and see who was at my door. And then he said, why didn't you tell me about these things? So he bought one.
I move to introduce this photo.
Okay.
No objection.
Thank you.
Exhibit 8.
May I publish, Your Honor?
Yes.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the Ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Nope.
It's on.
Okay, well, you know what, rather than use the pointer, why don't we describe, can you describe where you see the Ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. We could take that down, please.
Yeah, he rehearsed with her. I mean, they do that for all witnesses, like
How
you're
many
saying.
times would you guess you had been over to his house?
He already asked for that.
I don't know. More than 50,000. I don't even know. A lot. It was weekly.
That night, you told us that your husband went out to meet John at McCarthy's, the bar.
Yes, he did.
Do you remember your husband coming home that night?
Yes.
Do you have any memory of about what time he returned?
I'm guessing, but somewhere around 10:30.
So I'm not going to let you guess. Do you know? Do you have it?
I don't know. It was around 10 or 10:30. I can't be exact.
Did you see him come home?
Yes,
What was the forecast for that night and the next morning?
there was a blizzard coming.
Was that part of the decision-making of going out or staying home?
Yes.
At that time, when your husband came home, did you look outside? Do you have any memory of what the weather looked like around 10:30?
I remember the snow started to fall somewhere around 12 because I remember looking out the window and I could see it starting.
And that was the beginning of the snowfall?
I believe so.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Ms. Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Carrie, John's dead. And then she hung up. And then,
When she said that, did you have a chance to have a conversation with her?
no, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Carrie, John's dead, did you know what she meant?
No,
And did you say this was around 5:15?
this was at 5. She called me at 5 on the dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After you, or she called you again, did you have another discussion, or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about?
She's concerned about him.
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that point, I started to get dressed. I turned on the automatic car starter so it would warm up. Told my husband, I don't know what's going on. John didn't come home. And so I think my husband tried to call him, and I tried to call him. And my husband said, you're not going anywhere. It's a blizzard. He's probably on somebody's couch. And I was like, I know, but she's really upset. I'm just going to go. She wants to come here. I'm going to drive her car. And then I went out to my car and sat and waited for her.
When you called John, did you get any response?
No, I did not.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
When you called the police to look for Mr. O'Keefe, did you call 911?
No, I called the non-emergency line.
Do you know if that call was recorded?
I believe so.
I'd like to introduce an exhibit.
Okay. Any objection?
No objection.
Okay.
Exhibit 9.
When you called the police, what was your level of worry at that point?
I wasn't super worried. I mean, he didn't come home, but they were out drinking. So I assumed, like my husband said, he's probably on somebody's couch.
The second call you had with Miss Reed, can you describe her demeanor in that second call?
She was frantic. She was frantic. I mean, she couldn't find John, so she was very worried.
And you wouldn't leave Denise home alone.
It wasn't as loud as the first one, but it wasn't a regular conversation.
With the court's permission, I'd like to play the exhibit of the call.
Okay.
Brennan said, Tom said, my friend's boyfriend did not come home last night. They were at waterfall. And now she is calling me hysterical because she doesn't know where he is. You didn't take anybody outside the name of John O'Keefe, did you? John O'Keefe? Yeah, he's the Boston cop, and it will be on film.
No.
And he probably got a ride and passed out at someone's house. I don't know, but.
Yeah, no, we didn't lock anybody up or anything like that. And where does he live?
He lives on Pleasant.
He lives on Meadow, Pleasant. Okay, and where is the wife home? You said your girlfriend?
With his girlfriend, yeah, they were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yeah.
And so I said to her, even my husband had been out with him earlier in the night, but then he obviously came home. And he has custody with me to nephew because their parents passed away.
Okay.
And so she's home with the week and everything. They're home enough to be home. And so she's nervous because she never even called me.
Yeah.
So she's like, I feel like something happened. And I said, okay. Well, so call the area hospital and you'll be happy. I personally think someone probably picked him up in the car. I don't know.
Yeah,
No.
No. Okay. Again, it's more, it would be driven by you. She would have to, call in a conversation, and talk to us, but I mean, as of right now, it's more, he just didn't come home last night, is this common sometimes?
No, that's why. He didn't tell me. That's kind of why she's more freaking out. So I figured I called the other hospital, I got a call, Kansas police just to make sure he didn't get sick, but like I said, he's not complete about the very old rescue, so if anybody couldn't pick him up.
Yeah.
Please get it off.
Okay.
Yeah, we're going to have a little bit of party or something.
Yeah, no.
I don't know.
I don't say I wasn't there, I was stuck here, but we didn't get any calls, anything like that, nobody was arrested or anything like that. All righty.
All right, well, thank you.
All right, no problem, good luck. See ya.
Thank you, bye-bye.
Were you in your car when you called the police station and the hospitals looking for John?
Yes, it was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any
So
hospital?
her husband lets her
I
get
don't
out driving, looking for John O'Keefe.
How long did you wait in
That's
your
odd.
driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning and it was snowing. So it was
A real blizzard,
Not
you
great.
can't even see to
How was the
drive.
visibility?
not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen, who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed
If his
that you were
car is
going to
gone, that
meet
would indicate he's
at
not
Jen
there.
McCabe's house and then drive to John's house, was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropping Kaylee off or picked her up a few times. So I said, stay on the phone with me. So I don't know which house it is. And so when I got there, I pulled in the driveway and
guess his
there
car
was
was
some
there, so.
conversation about,
Can I back you up and just ask you a little bit about the drive there? I don't
Yep.
mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
oh, it's quick, probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want two cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous, but I was in four-wheel drive. I have an SUV.
Oh, he was home. He
You
just
mentioned
didn't
you
see
know
him.
exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway. So I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway. And at some point Karen said, my taillight. And I looked and Jen she must've had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
If she knew she hit
Could
John,
you
why
see
would she
that
talk
as
about a
you were
taillight
parked
out?
right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No,
Did you think anything of it?
no.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped. And then the next plan, at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No,
You followed Ms. McCabe?
yes,
Where did you go?
to John's house.
Did you arrive?
Yes,
I want to ask you some questions about when you arrived and what you did next.
okay.
When you arrived at Mr.
It
O'Keefe's
makes no
home,
sense they
you're in
would go
two
to
separate
34
cars.
Fairview
Pulled
instead of
into
going back to
O'Keefe's
John's
driveway
house.
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus
Correct,
and the defendant was in the passenger seat.
yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
When the Lexus was parked by Ms. McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
I'd like to approach.
Okay.
I'm going to show you a photograph. Do you recognize what's in that photograph?
Yes, that's John's driveway. That's Karen's car on the left and John's car on the right.
Do you recognize both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes,
Do you recognize it as a fair depiction of the motor vehicles?
yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out and there was much more snow. And there was snow coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the light.
Where they travel and all that, why don't they just have a map,
Nope.
big blow up of a map showing where they travel? They can point out where they traveled and
There's
stuff.
no objection, Mr. Jackson.
No objection.
With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes,
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
yes.
And whose vehicle is that?
That's Karen's.
Is that where it was parked that night when you went into the house?
Yes,
And the motor vehicle to the right, you recognize that?
that's John's car or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay,
Do you recognize that photo?
yes.
What is it?
It's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours to you?
Yes,
Do you notice anything that's distinguished in that photo?
the piece that's missing in the taillight.
Which one?
The right passenger rear.
Do you know when, I'm sorry, do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5
Yes,
or a little after 5?
yes.
I moved to introduce this exhibit.
Okay.
No objection.
The court's permission to like to publish?
Yes.
It looks solid there. I mean, you can see less red on the right side, but it looks like it's solid.
After you arrived at
Snow
Mr.
is a
O'Keefe's
fixed
house,
bit more on
what
the
was the
right side
plan
than the
to go
left.
inside?
And there
What
was
were
a
you
big
looking
drip
to do?
behind the car.
To go inside and look and see if he was passed out somewhere.
Doesn't look like
So
a
we went in
smashed out, massively
through the
smashed out
garage.
taillight.
and I started looking. I think Jen ran upstairs to Kaylee's bedroom, and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes, were you calm?
I mean, I was worried, so we were, at this
There's
point,
not a depression there where
Jen
the
had
tail wasn't
already
that right
established
tail
that
light.
they went to her sister's.
Sustained.
Okay.
Jen had already,
Now let
Hold
me ask the
on,
question.
Ms.
I'll ask
Roberts.
the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point, as you were looking, did you see?
It's like they're looking for a little
Yes.
lost
Was she looking
toddler or
with
something.
She was
It
in
just doesn't
John's
make
room.
any sense.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No,
Did she do anything?
no,
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said,
Well, let's not talk about what was said. Okay. Let's
Well,
just talk about
the plan
best
at
you
this
can,
point
your-
is
your
to go to
memory of what was
34
done.
All right,
Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question
Okay.
because we can only get one person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
the plan was to go back to Jen's sister's house.
Who made that plan?
The plan?
Karen wanted to go back there.
Well, tell us a
She
little
did
bit
from the
about that.
get-go.
How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall. And Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's. And I said, no, we're going to go to Meadows and we're going to drop the car and we're going to look there. Then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived. So we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat.
Did you
And Jen
begin?
was giving directions.
Did you begin your way towards Meadows?
Yes,
And it was Miss McCabe who was giving directions?
yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing anything like looking or searching?
Well, yeah, we were looking on both sides of I was looking on both sides of the road in case he was walking home.
Did you see Miss McCabe searching?
Yes, she was looking out as well.
Describe a little detail about what you saw Miss McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat and then she would be in between Jen and I, in the back seat and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
She was worried about him.
There was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house
She
on
seemed to
your
be
left side,
walking,
your side, or on the other
really?
side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white knuckling because it was getting slippery. Karen wouldn't put on her seatbelt, so because she was in between us again the whole ride, and then sitting back. But she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, at some point, Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about, but apparently Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
Objection.
I'm going to allow it.
Bella
So
lived
as you
near
approach
34
tell
Fairview,
us what
apparently.
happens.
As we approached Fairview at the house. You mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached
right
the
back.
house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's now kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is, so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
There, Mr. Brennan, I need to see counsel at sidebar for just a minute, please. Regarding. All right, so Ms. Roberts, we're going to have you come back tomorrow.
Okay.
Jurors, we're going to break for today, so we're going to send you home. The same 3 cautions that I'll tell you every single day. Please do not discuss this case with anyone. Don't do any independent research or investigation in this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Please be extra careful with your social media. Okay? We'll see you tomorrow morning. Thank you.
Folks, all rise, please. Jurors, hold your books, put them on your seats. All day.
Yeah. So, all right. So we're done for the day. I just missed it by a couple minutes. So Yeah, there's only a couple inches of snow on the ground. That's what it looked like when they're out driving around. It started picking up after 6 o'clock. So let me go ahead and switch off here.
Those motions gone through.
Are they going to show any of the attorneys? Here we go.
To enforce compliant with the court's April 16th ARCA discovery order and the motion to continue. All right, thank you.
Here we go.
Sorry, Chrissy, I didn't.
Motion continue. We're not going to get to see this? Wow, this is strange. Why wouldn't they allow us to see this motions hearing? This is there for the public to see. They're going to go over this stuff without the cameras? I think what's going on is there's something that Brennan wants to introduce that he knows the only way he can get it in is to create an extension of the trial. So is he wanting to move the whole trial? They've already started the trial, so he's going to start it and then stop it. We had 1 day so far, and then they're going to move it on to a different date to start again, or have a big gap in some of the trial itself. I don't know, but it reeks of desperation. You can't trust this guy. I do think that he was actually more tolerable than Lally in terms of a number of objections, but he sure gets mad. And when his mad persona comes out, it definitely is something that turns off the jury. He tries to be sort of nice and likable when he's doing direct, but as soon as he does redirect and he's angry about all the points the defense brought out, then you see the anger in him. And when he's an angry version of him, then it really, I think, turns off the jury. Russian Aloha, you're saying if Karen Reed said John's dead, then why no mention of when she called the police department to ask if John had been picked up or to hospital or jail, why no mention of that? So why wouldn't she say, why is he dead? I think she said she doesn't remember if she called back or if Karen called her back. Why wouldn't you call back right away? What do you mean he's dead? What's going on? So this just doesn't really make sense. The time sequence of this. And then you would ask, what do you mean John's dead? And then she says, well, I think he got hit by his plow. So, all right, well, she should also be concerned about the fact that if he doesn't come home, there's a bad blizzard. It doesn't lend itself to her sounding too concerned. She does go over there mostly because of, I think, the hysteria of Karen. I think if Karen was not alarmed enough to call her at 5 a.m. and acting so distraught, then she probably would have just, oh, I'm sure he'll show up eventually, and then pretty much end the call. But we know that Karen was frantic, and very much upset about this, about John not coming home. She knew something was bad. Eddie Mack, you're saying, I'm not satisfied with all the messages have been provided. I can't allow ARCA testimony to be given the lack of candor shown by the defense. If you remember those motions that were due, let me see if I can pull those up. That one order that the court had for the deadline at ARCA. She actually gave an order to ARCA, some out-of-state business she gave an order to. This is really bizarre. What she was doing was she's trying to catch the prosecution in a lie and not disclosing Rule 14's reciprocal discovery. So then she can just completely banish ARCA from being called as a witness. And that's why she won't let him talk about ARCA at all in the opening. That's why, is because if they mention ARCA in the opening and then they don't, it makes it look worse for the defense that you couldn't deliver what you said you would in your opening. So she's totally shutting the door on the opening for mentioning ARCA, because she's working with Brennan to come up with a reason why to completely exclude them, not just limit them, but completely exclude them. That's just so bizarre for a judge to order a witness, an expert witness at that, to produce all the information of communication with the defense attorneys, because what the judge is basically saying is the defense attorneys can't be trusted, and between the expert witness and the defense, I'm going to try to find something to pin an exclusion on where I can deny them as a witness. I'm looking for that order now. Stand by. Here it is. Make this full size screen here. Stand by. So this is a deadline by April 18th at 5 p.m. to produce Commonwealth any outstanding discovery, and then addition by April 18th by 5 p.m. Defendant must disclose to the Commonwealth any oral agreements, representations regarding anticipated reimbursement or payments to ARCA on behalf of any member of ARCA in the defense, including the defendant, is further ordered by April 21st. The defendant must disclose to the Commonwealth any testing underway, requests that are contemplated as to any testing underway, requests that are contemplated is not completed, and the date testing will be completed and the results of any testing. After receiving the above discovery, the Commonwealth moved for additional relief. So that's what they're trying to do right here, is try to block, because we had a deadline yesterday at noon. So this basically opened the door for Hank Brennan to try to find additional relief to keep out the ARCA witnesses. So that's what this whole thing is. It's an effort of the prosecution, and he's joined at the hip with this judge to try to. Sorry, I just X'd out there. So that's going to be something that is right for appeal. It's so obvious with this judge that ARCA is this case, slam dunk win of this case. Nobody can come close. So I believe that no matter what, how to find some technicality or something like that to try to keep out ARCA. So I'm just looking through questions. You guys have any questions now? Sam, you're asking, is that why she waited to address ARCA motion so the defense wouldn't have time to correct it? It's all ambush. You know, Hank Brennan's talking about he doesn't want to be ambushed and all this kind of stuff. I mean, for crying out loud, this is a investigation that was already done and completed before the defense ever got a chance to talk to ARCA. This was not defense hired expert that was looking to make money and realized that, hey, if we say something and make findings that are favorable to the defense, then we're more likely to get our in-court fees paid for, and I'm going to make a lot more money on this case. It's not the case at all. These guys were hired to be neutral fact finders for the federal government, and doing so, they had no financial incentive to say things one way or the other. They just called it like it was. And so for this prosecutor to make this a dog and pony show, that this is something that defense manufactured evidence with this expert team of ARCA witnesses, and they're hiding something, and they got something that's nefarious, and I need to find out what it is because they're hiding the ball from reciprocal discovery and all this kind of garbage. I mean, it really shows how weak their case is. So all the medical information that they have from their medical experts, that's not enough to show John was hit by a car. You don't have your own experts that you feel confident in now that you've gotten somebody besides Trooper Paul, this Welcher guy, to try to be your counterweight to ARCA witnesses. So it's just very much like we saw in the beginning of the day when the judge had a sidebar, when Alessi stood up and said, we have, okay, I guess the judge is back live, so stand by. I got to open a new tab.
Of their decisions, we will not have the ability to rush through, have Dr. Rentschler come in days before his testimony, try to reconcile, be inadequate.
There it is.
I've had
Trying to keep it out.
brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court, that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new, we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Alessi, is this you? I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond.
Good to have Alessi.
Almost every allegation that's been made. We haven't had an opportunity. So I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders. And I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so.
Why don't you let him talk, Judge?
Referenced in the exhibit.
You never cut off Brennan, never once.
I asked if Mr. Jackson, if he provided them, because my order was clear, they were to be provided. And he said no. And I asked you at sidebar whether they were deleted. And you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, doesn't the aren't the ABA guidelines the counsel is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to
ABA's American Bar
experts. I'm
Association is no
unaware of
controlling
that.
To
authority.
your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages leading up to trial when I was told that by you that there was a pause email and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Lessie.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there
Great
has to be
passion.
more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must
Right.
be more.
Right.
We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarized all of the
He
communications.
keeps saying he didn't get all of
Yes,
it,
we don't have the text of the text message,
and he can't prove it.
but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her texts and the text of her text messages. There is nothing else in existence to provide an important.
But Brennan says there is.
The defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any
Great point.
communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have. And in addition to that, we created a document so that it would be easier.
Great passion.
We're the one who showed all
Show
of
that
these
you're
text
angry at this
messages
judge trying to
from
pull
Mr.
this
Jackson
stunt with the
historically.
prosecution.
We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect, because we turned over, and we did it recently and consistently. We've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved. And there is no discovery violation, because we can't be in violation of not turning over something that doesn't exist.
All right.
Great.
The second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February of 2000 or February 19th,
End of January.
we finally get the raw images from Aperture in the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images in scans. We move and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it. And by March 24, we receive the PowerPoint that was supposed of the Aperture that was supposed to have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes
So
were.
why don't you highlight them very quickly, because
I
need
will,
to
Your
say
Honor.
something.
I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the taillight was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes.
2 days.
And then we started to respond in
End of March.
more
Or in April.
information on March 27th. We responded
Less than a month
to
ago.
the Commonwealth's revised PowerPoint and the Welch report. And then the last 2 items, we renewed our request to preclude Dr. Welcher on Delbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial. 6 months. And the defense took merely 2 days after they got the final report of Aperture to retain ARCA.
Shame on
point
you,
I want to
Brennan.
make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post haste. And they are working post haste. But, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with
Terrible.
regard to the allegation that there was something said, that there's some surprise
He's
that there were
nailing
so
it.
many text messages. On June 10th, 2024, and I've got the transcript on an, albeit on an electronic device, right in front of me. I just got it.
It's all grandstanding by the prosecution.
Mr. Jackson read a text message right live that he had with ARCA. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week, but not next week. So I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Thank you. All righty. Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week. So I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages as opposed to emails. Text messages about scheduling, about other administrative matters. Mr. Brennan is
Already
completely
blocked her.
free on cross-examination of ARCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
All right,
What's next?
so
Wow.
we need to wrap it up because there's something I want to say.
Certainly, Your Honor, I'm going to wrap it up in 10 seconds. There are no violations of
No business
any
being a judge.
discovery order, no violations of this court's order. And with regard to the retaining of ARCA, because we're the defense, we acted expeditiously in response to the information we're getting. And this can be tested with ARCA, the statement I'm going to make. To this date, ARCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right.
Great job.
All right. So as you all know, I previously, why don't you have a seat, Mr. Alessi?
Thank you, Your Honor.
Great
Previously
summation.
found,
Nailed it.
and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations.
How?
We need to figure all of this out before you're allowed to call these witnesses. So,
Oh my
we're going
gosh.
to have a voir dire hearing this Friday. I know we planned on having you. I need the ARCA witnesses here Friday morning. So we need a voir dire if you intend to
They're
call them.
defense
A
witnesses.
voir dire on all of this, and I will be sending an order for production of
Oh my
records. I
gosh.
just need to amend it for ACA to bring all
How can
these
you order
items
out-of-state
with them.
witnesses to
So
show up?
Friday will be for ACA for a voir dire hearing in the morning. So we'll see you
Just on a
tomorrow
whim
for
without any
trial,
coordination
Friday morning
whatsoever?
evidence.
Experts?
May I inquire briefly for scheduling
This is
purposes?
just
Yes.
out of control.
In light of the hearing on Friday, will it still be half a day, or are we
She needs to
expected
do
call
this.
witnesses on Friday?
No, it will be, if we could do, Mr. Leslie, how long do you think this voir dire might take?
What the heck do they have to be voir dire for? You already know their testimony.
I've talked to ARCA and I've got to understand what they have and what they don't have. So I think, in fairness, I think it could take some time.
She's gunning to have them
So no
excluded.
witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
She wants them out
Yes.
even more than Brennan.
All right.
Brennan
so
realized
then I
at
will
least
issue an order hopefully before the close of business today. Jimmy, can you stay and get this out?
you
to
can't
me?
block them
Okay. All
completely.
right. Thank you.
Wow, this judge is, I don't know what to say. This is just so, this judge just gets crazier and crazier in her rulings. The actual trial itself today for the one witness we had in the beginning, it wasn't too bad with Brennan objecting much. And even on the second witness, Carrie Roberts, we just heard her on direct some, but it's yeah, absolutely a disgrace to justice what this judge is trying to do. And I got to take it out of presentation mode here. Thanks, John. I cannot seem to recall that. So there's I just cannot believe a judge would go that far off in left field trying to help the prosecution even more than the prosecution wants to be helped by this judge. So it's like I say, even if ARCA doesn't get in, this case is one. It should be, but the most damaging witnesses for the prosecution are the two ARCA witnesses. And that's something that completely destroys the prosecution's theory. They don't have anybody else to rebut with credible expertise like the two PhD experts for ARCA. So that's what she needs to do, is try to exclude them. Miriam, you're asking if she excludes them, can they file an interlocutory appeal? I mean, I would file something, a writ or something like that. It's just a constitutional free zone in that courtroom. Yeah, it is insane. But you know what? The more we see how insane this court system is there in Judge Canoni's court, at least more people maybe wake up and see how much you can get railroaded in Massachusetts. This has even gotten crazier, and I can even have predicted that she's going to interrupt so in other words, jurors are not going to listen to witness testimony Friday. She wants to have ARCA witnesses show up just because she said so. She's not allowing them to coordinate any schedule for them. And yeah, it's a total pretext to exclude them. She's just looking for something to be trumped up to kick them out. And that's what it comes down to. So it doesn't matter what they say. She's going to try to kick them out. What that beeping noise is. John, if you could help, I don't know what this noise is. I don't. There's not going to be a trial, any semblance of a trial for Karen Reed. So I don't know where this is coming. Oh, hold on a second. Oh, okay. There we go. Thank you. It was actually the law and crime, or the I should say the Boston 25 feed that was doing that noise. Sorry about that. Thanks, John. Let's see here. So she basically is trying to do the same kind of Hank Brennan maneuver, which is basically beat these ARCA witnesses down, put them under such a spotlight that they just basically don't even want to cooperate anymore. That's what they're hoping happens. Rosa's saying it's like watching a slow motion train wreck to witness how corrupt this judge is willing to appear. Mr. South of Boston, I'm a retired law enforcement officer. Thank you for your service, sir. There's many outstanding officers. We have the best law enforcement in the country across the board nationwide, but there are some really bad ones as well, a few bad apples. And you've served 37 years. You've worked in all aspects of your profession, including as a traffic homicide investigator. She is not guilty. Thank you, sir, for your comment on that. It's nobody, like I said this morning, anybody that's worked in the criminal law setting, either as a judge, prosecutor, or defense counsel, this whole case, it's just, you can't imagine it could get this bad, that the judge can be that bad and the prosecutor that bad. And why do they have to be that bad? Because they know for a fact that they can't win a case. They can't stick it on Karen using normal rules of procedure and normal constitutional protections. So what do you got to do? You got to throw out the Constitution, get rid of it, and just have this be a star chamber. Doesn't matter. It's going to get busted on appeal. They don't care about that. Well, that's what I think she's been gearing up for. That's what it looks like to me. I think she does have the audacity to do something like that. So, yes, I do. I think she's lost it that much. I think she's that beholden to the Morrissey team. Just think you're willing to throw your whole reputation out to help Morrissey, your worldwide reputation, you're willing to throw that all down the drain just to help out Morrissey. Yeah, I'm going to call her still a judge. I'm not going to call her any other names other than Judge Canoni or the judge. I don't. This is not something that I'm going to say anything other than what she is as a judge of a courtroom of the state of Massachusetts. But this is what happens when a judge is unchecked and doesn't care about the reputation, and they don't care about the Constitution. Yeah, I think this thing will probably last more than 8 weeks. South of Boston says you went to school with a member of the defense team. Well, that's interesting. And probably Yannetti then, if you're from Boston, that's where he's from. Constitution free zone in Norfolk County. I think the defense has a great day today. Their opening was just crushing it. The prosecution's opening was just a lost Brennan pacing forth and back in front of the jury half the time, not even having his body face them. It was like his side view and his back view to those that he's walking past. So really strange behavior for a prosecutor. Again, we have another law enforcement officer here in the house. Linda is saying my son is a law enforcement officer and always said that Karen Reed is not guilty and those cops are all corrupt. Yeah, I would say they are all corrupt. I think the only one that's had a conscience so far that I've seen is Trooper Paul, and he's just put under the gun because he's going to lose his job otherwise. But he just made up whatever he had to try to keep his job. You could tell he wasn't comfortable in what he was saying. Hey, Swampy saying, why wouldn't appellate court weigh in on this since it's such an important case prior to the trial going much further? Well, unless they do some kind of appellate thing about the judge keeping out like ARCA witnesses or something like that. Writ of mandamus, which is basically an order request for the higher appellate court to force a judge to allow ARCA to testify. But I mean, this is so much time consuming stuff. This judge has zero credibility as a judge. I think she's been a lifelong career defender before she became a judge around 2009. Or no, I think it was 18 or 19. Kate, you're saying he thought he was clever walking around like a theatrical play. Anna says, I can't take this judge. I don't even know Karen and my stomach is in knots. Sean Thompson, 150 witnesses. Why does the prosecution need so many to prove a car hit John, which it did not? Yeah, I mean, basically, this is like a hit and run DUI. Can you imagine hit and run DUI having 150 witnesses? Why is that? Fierce like Frida, I think the Commonwealth saw what happened during the cross-examination today. Hank Brennan is scared. I think his scared state of mind was revealed on his redirect for Mr. Nuttall. The Bath girl saying, "Why will she be able to exclude him? What will her be decision? What will her decision be made of?" Well, she's going to try to find a discovery compliance violation, and if there's a discovery violation, and it looks like she's going to try to find. She's already said the defense has acted with bad intent and deceiving the court, or words to that effect. So she's basically going to say that they don't deserve to have ARCA because they have not been compliant with reciprocal discovery. Reciprocal discovery means the prosecution is willing to give you full discovery, and defense, you're saying you will reciprocate in kind. And so she's saying defense isn't reciprocating in kind to the prosecution's discovery, but the prosecution's discovery release of information has been very slow, and they're the ones that should be having evidence kept out if anybody's going to have evidence kept out. But anyway. Julie Nielsen, you're saying voluminous emails were just entered into Donna Edelson's case and Buzz's may delay the trial. It could, if you get a whole lot of them, that's possible. I would say they need to do some kind of writ, but even that is dicey. She cuts off Alessi. She never cuts off Brennan. I mean, she's just basically an arm of the prosecution. Miriam, you're saying, for real, I was telling my 17-year-old who just saw the autopsy photo said John O'Keefe was beat to death, not accident, and I'd probably need to seek therapy if Karen's convicted. Fierce like Frida, what do you think AGO asked during cross of Carrie Reed? I don't recall that they asked a lot of questions about what was said by Karen. And even if Karen did say, yeah, did I hit him? Did I hit him? I mean, a lot of that, because she had alcohol in her, she had probably some kind of blackout and didn't remember going to 34 Fairview. And with that admission, that gave, what defense will probably be arguing is that that gave Jen the idea to go ahead and create this scenario where she's the one that struck John O'Keefe. But the problem is, you need to have forensic evidence align with that, and they didn't think about that part of it. Think about it. Alessi, he's working for free, and he's working from that global law firm DLA Piper. So he's really got to believe in his case for him to do that. Linda, wow, they arrested a guy for filming outside. This whole thing about 200 feet from the courthouse, it's like a ghost town there around that courthouse. Unbelievable. Unbelievable. What's going on there? The federal judge wouldn't intervene and do anything to fix it. Yeah, we're already beyond that. It's not a fair trial. We're already beyond that. I think it's unconstitutional to hire somebody to go after somebody individually. You're basically hired Hank Brennan to go after somebody individually and personally. Is that not shady or what? Because they have a motive to get a conviction. That's all they care about, getting a conviction. They don't care about staying in that position and having this case stick on appeal. It's just grind through this process, wear out the defenses, beat them into submission. So I would say what can help out is if you guys can, if you're motivated enough, then help out the defense team and give them some money. Help them fight this corruption. Coach George is saying they're so scared of ARCA, probably Morrissey's behind this. Well, he's the one that told them not to let ARCA being hired by the feds come out at trial. So they should have dismissed the case at that point. Janice Meyer, if FBI needs to step in, these masked thugs will prosecute. Thank you, sir. I mean, that's pretty courageous for law enforcement from Boston as well. Just like we saw that sergeant that came out and said this whole thing was a scam, this so-called investigation. Ninja Gal, laws need to change. No human should be allowed to run rampantly like this judge. Most judges would not want to be this biased, especially on live coverage. It's just bizarre. I'd be calling out the judge every chance I got. If I thought she was being biased, I'd call her out on it and say, renew my motion to have her recuse herself, declare a mistrial. Anna, you're saying text messages with experts that reflect strategy, analysis, or litigation preparation are protected under the work product doctrine. You're citing a case there as well as federal rule of civil procedure 26B. I think what they may have, those reciprocal discovery could require all of that, but maybe not text messages as Alessi was referring to. Anyway, it's just, like I say, an excuse to try to keep Arca from testifying. Fierce, like Frida, do I think the defense will be asking for reconsideration for the FBI agent to talk about proper police procedure? I hope so. They need to cite case law to support that. Lynn Dowling, you're saying Judge Canoni behaves as if she has no accountability, like after this, everyone will forget and just go home. Well, there's going to be an appellate record. This is going to go on appeal. So eventually this is going to come out. There will not be a conviction against Karen Reed that's going to stick on appeal. No, it's not your imagination. Sherry D saying it is my imagination. Judge Canoni seems to always rush the defense. Yeah, everything's always a rush with the defense, but not with the prosecution. Just another way she shows her bias. Mr. South of Boston, every case with this judge needs to be reviewed. Think about it. If you got a judge that's beholden to the prosecution, that you have problems, major problems in justice. Okay, Carrie B, you're saying it was 200 feet last year, now 200 yards. Yeah, 200 yards. That's two football fields length. I just wonder if there's I just wonder if there's a effort to have it be publicly broadcasted that ARCA is hired by the feds, but you know, when people say, well, how can you be a defense counsel to defend the guilty? You're like, look, you need defense lawyers to fight this kind of corrupt government action. Yeah, this is corruption at its finest. When you got judges that'll hide the ball from the jury, it doesn't get more corrupt than that. Lucas Knight, you're asking, what do I think the judge thinks the defense is broken? It's really confusing me. It's just disclosure of communication of some sort. Communication, just because Brennan says that there's more there that he thinks that happened between the prosecution and ARCA witnesses. Therefore, it must have happened. The judge is like, oh, we got to find out. We got to bring him in here and we got to like grill them like there's some criminal thugs. Yeah, we have some really good judges. It really inspires confidence and trust in the judicial system, the criminal justice system in America. But when you have judges that are this horrible, wow. Okay, Sam, you're saying every attorney keeps saying appellate record, but doesn't that mean Karen will be in prison while that goes on? Yeah, that would mean she's in prison. Most likely she's going to be in prison if there's an appellate record, depending what she's found guilty of, if it's a misdemeanor or not. But they want to throw the book at her, so Yeah, I have not followed New Britain. Paul, you're asking about my opinion on Judge David Fleischer. I haven't seen anything about that judge. Jody Volkmer, you're saying she has never held trial on Fridays. Never. Wow, that's bizarre. What judge doesn't have trials Monday through Friday? That's bizarre. Hey, Swampy, imagine what Karen Reed's attorneys are going to say about the judge once this case is completely concluded. Well, imagine what they're thinking now. It's just bizarre. This shell game, who's on third kind of thing about, hey, what about the communication with ARC and all this? It's just mind numbing. It's all just an effort, a conjured up effort by the prosecution, because they know they got a judge that would listen to this garbage and entertain this garbage. For her to call ARCA, make them come in out Friday. Wow. Yeah, I think Alessi's the best one to call the judge because he doesn't practice in front of her on a frequent basis like Yannetti would. And he's so convincing and persuasive in his argument, very factually specific. He's a credible guy. He's a likable guy. Paul Richards, I'm surprised she let the arm photo in. They tried to keep it out. Yeah, that photo's really got to wake up the jury, wouldn't it? It's common sense. A vehicle would not cause that kind of injury on John O'Keefe's arm. Hey, Swampy, yes, she's helping them cook up anything to keep those experts out of the trial. Kelly, you're saying you feel like you're losing your mind with the Commonwealth's games. Yeah, it's not fun to cover this. Really, it's really disturbing and it's upsetting and it's just really sad to see this, that people have no respect for treating people fairly that are in the criminal justice system. It's all a game to trample on people's constitutional rights. Jody, you're saying that ARCA is from Pittsburgh. That's what I thought. I knew they're from somewhere in Pennsylvania. Lum from CMU. CMU's Carnegie Mellon University, I believe. That's what you're referring to, CMU. You know what the judge hasn't done when she says that? Remember when she mentioned the defense counsel, specifically she's referring to, no doubt, Ellen Jackson, saying that they had involved in, however she said it, I forget the exact words, but they were involved in deception, deceiving the court, deception. And this is something she never said. She never made findings on what they did to come to that conclusion. So she's just making a finding that's a declaration without walking through an order saying, this is what I find. I find on such a date, this is what was said by the defense. On such a date, this is what they then said that was contradictory to this. Or on such a date, this is what we found out that it wasn't indeed fact because this was proven by such and such evidence that came to the court's attention. So she doesn't lay it all out how she made findings that they did anything to deceive the court. Yeah, so it's like I don't think I'm going to do live stream day in day out. I think it's too probably too much upsetting for me. I'll maybe have to listen to it in the background, but I don't know. I never thought I'd do a live stream today, but seeing this whole garbage about they can't mention ARCA at all in their opening. Wow. I've never seen anything like this in all my experience. I did have one case where the judge kept out some critical evidence in my theory that somebody else had done it, like a third-party culprit, and it didn't become an appellate issue because it won it on appeal. I'm sorry, won it with the jury. The judge was absolutely terrible and didn't allow me to present that, but wound up winning the case, so it didn't become an appellate matter. Sandy, that's a good question. If ARCA can't make it, will she throw them out? So, never seen a judge where they just order experts to show up from out of state. Today's Tuesday, so Friday they have to be there. They have to leave from Pittsburgh to get up there. I mean, that's like to Boston. So let's see, you're talking about like a 10-hour car drive to go from Pittsburgh to there. And if they had to fly, there's not going to be a direct flight. So you're talking about a whole day of travel both ways. What? I mean, she can allow them to testify via Zoom. Hopefully that'd be the case. But she didn't clarify that. Okay, Brit Chick, I thought if she keeps ARC out, then the defense would need time to get another witness, right? No, that's wrong. They don't get another witness. That's it. If she keeps out these experts, they don't have any backup, okay? Callie, I work at VA PGH where the human biomechanics research was done. The ARCA experts are so respected and second to none. I can see that. I do not believe there's better qualified experts than the ARCA witnesses. They're just so phenomenal. So you say you work at the VA, and is that Pittsburgh PGH? I don't know what that PGH means otherwise. But yeah, there's biomechanical research done by DOD and the VA. So Patty Paralegal, ARC has offices in Florida as well, but the crash studies work in Penns Park. Are you serious? Says that the governor has long connections with the DA, and many of the players, the corruption goes up to her. Are they all hiding to risk life in prison for RICO? The best and only really check they have to prevent Karen Reed from going to prison on a bogus conviction by this jury is if the jury sees this garbage for what it is, even though it's very limited, much of it that the judge is trying to keep out. This is the equalizer to the government's outrageous behavior. Ninja Gal, I can't find any lawyer whom is a professional, not feel this is the most corrupt trial in the history of America. This is exactly why transparency is needed. But it's not getting her anywhere right now, right? If this judge is continually willing to be a cheerleader for the prosecution. Maya, Rodriguez Sorensen, Esquire. Judge Canoni doesn't seem to like case law or finds a reason not to follow it. Well, she just cherry picks Massachusetts case law. Massachusetts case law is, from what I've seen, just absolutely not following foundational constitutional law principles that I find just normal routine things that occur in other states and in the federal system that is just completely different type of mentality there. What's commonly understood meanings within the Constitution in the court system there and appellate decisions from Massachusetts, they just don't even, they're not even on the same page. Like I say, maybe it's going to appear via Zoom, but she didn't clarify that. So I thought she said she wanted to see them Friday. I think her and Hank just want to harass them into submission where they just give up. So let's hope they have the courage and still stick with this. My utmost respect to them. Mike Boyer, will you please allow people to come on as people who are jurors to talk about day one? I don't know what you mean by people who are jurors. If they're on the jury, they cannot speak. Are you saying to act like you're a juror? What your take is on it? This Susan is saying Arco is a very reputable company hired originally by the FBI for $500,000, who was then determined John O'Keefe was not hit by a vehicle. LESB, you're saying judge is trying to disqualify them on a minor technicality. Her behavior and conduct really makes my blood boil. It should. That's what she's doing. She's going to gun them down. And the way I heard Hank Brennan talk about today is like he was just trying to prevent them from introducing new information. But I think the judge wants to, that's why she was reverting back to something they had done previous to mislead the court. That's why I think she wants to keep them out completely. Yeah, compared to the Depp trial, says Ellie, and many other trials I've watched, this courtroom is so unprofessional and disorganized, and all their equipment is so outdated. Yeah, definitely. Sandy, yes, it will be overturned on appeal if she's convicted of something, but I got to believe she will not be convicted of anything. Julie Nielsen, any explanation why the rogue prosecutors? Well, what they want to do is back the cops. So if the cops are saying this would happen, they're going to back them up no matter what, especially when there's a cop that was killed. Little do they realize that this is something that the evidence does not bear that out. And so rather than stopping and telling the cops, hey, look, this is not something shady going on here. We don't have a case to win. And what they wind up doing is they're stuck on going forward with what the prosecution, law enforcement types say happened, and they look for experts to try to say that that's what happened, just like Trooper Paul. And so they just keep propping up a dead on arrival case, and they're hoping the defense doesn't have a good lawyer, and they just wind up having her plead to something. The problem is from their case is that Karen's lawyers are actually going to fight for this, and they're fighting it every step of the way. That's why they overcharged the second-degree murder case, hoping to make her plead guilty. Just wait, charging this with second-degree murders is so ridiculous. There's nothing about Karen's behavior that looked like she wanted to kill him. California girl, 209. Early on, I saw what was going on here and just scared me that I did not want to continue watching this hearing. I feel like there's a bigger picture here from all the same club. Yeah, that's there is a bigger picture here. What's going on? Aunt Nancy, you're saying there's absolutely no way the judge can eliminate ARCA. Well, she can if she just conjures up some kind of technicality. Whether that's going to result in her conviction by not having them, I would hope not. But if she is convicted without ARCA, then that's going to get busted on appeal. One of the grounds to get it busted on appeal. See tonight on Young Jerks. I'm not coming on there tonight that I know of. I did talk with Mike yesterday, and I'm going to be on Friday night. He sent me an invite. I have not got to it yet, but I believe 6:30 Eastern time, Friday night, I'll be on Young Jerks. Thanks, guys, for your nice comments. And like I said, I just don't know what I'm going to do tomorrow on this case at all. It's just going to be something I guess I'll decide over the night. Like I say, it's just spur of the moment thing. I got mad and I was shouting and so Leslie and John encouraged me to do a live stream. So I said, yeah, I guess I might as well. Yeah, it's desperation. The judge is desperate. The prosecution's desperate. Objection, Bevy, you're saying I don't believe for a minute ARCA will get in. I mean, it's really a concern. It looks rigged. It looks rigged to keep them out. That's what it's looking like. Most people probably didn't believe me when I said it, when I first came out and said that, but I can tell political agendas pretty good, and that's what it's looking like. If not to keep them out, intimidate them to the extent that they don't want to cooperate anymore. They're out-of-state witnesses. They don't have to cooperate. They just say, we don't want to help the defense, and here's your money back. Boy, that's for sure. Moral of the story, never visit Canton, Massachusetts. Robert Fay, sad day for anyone who wants to believe in justice in this joke of legal system. She probably was really upset, the judge, that it went good for the defense today. The prosecution, terrible job. Hank Brennan, terrible job in his opening, terrible job with his first witness. And we didn't get to see Carrie Roberts get grilled on cross yet, but it's gonna be that way tomorrow for him. He's not gonna have a good day once she gets crossed. Portraits in your mind. What the federal government have to say if ARCA is not allowed to testify, especially if they show Friday. Why did they put them in this case if not? Finger red number 1. Well, they were released just recently to be engaged by the defense. So the feds do want full cooperation from ARCA. They're not restraining them in any way anymore. So the feds have totally backed off. Are you serious? If the judge's rulings are deemed exceptionally egregious towards the defendant, can she be held personally liable? No, she has qualified immunity. So it's really hard to sue any particular judge. Next to impossible here in the American justice system. Hey, Swampy, they want the jury to say, well, she didn't mean to kill him, but she did kill him. That's manslaughter. That's the best they'll be able to do. This is so sickening. Well, no, they actually do want the jury to convict her of second-degree murder. How baseless that is. Lucas Knight. Doesn't matter what the Leslie said, judge doesn't care. No, she doesn't care. Doesn't care at all. There's an agenda. And the truth and justice will be crushed en route. Yeah, Mandy, it's totally rigged. Everything about this case is rigged. Yep. That's what I'm saying. Ellie SB, my biggest worry is that the jury will feel like they need to punish her for drinking and driving and will bend on one of those charges. I hope defense addresses this. Yeah, leaving a bar with multiple cops there, driving home with a cop, or driving to 34 Fairview with a cop, and yet they want to say you should be convicted of drunk driving. Oh, it says here, Glamis sues. The McCabe's and friends have been harassing Dr. Wolf's family since last June. They harassed the company so much they closed their X account. Wow. I mean, with ARCA, they were limited in what they could disclose and get for information from ARCA because they weren't released by the feds to give the defense the information that they wanted. And now they've been released. Now they're asking to do additional testing. And now Hank's going to object to that. And what he's doing, he's not really wanting to have a delay in the trial. He just wants to use that to pressure the judge to say, see how bad this is for us, and I'm so unprepared. It's so meaningful. I'm willing to delay the trial. He doesn't really mean that. He knows the judge is going to delay the trial just so his expert has time to try to rebut the ARCA test or tests, whatever they run. Lindemont, do you think John O'Keefe was set up for his murder? I don't know if it was a intentional setup from the time he left the bar, but stuff is fishy. Everything's fishy. I'll just put it that way. Suspicious indicators, very suspicious indicators from the way Jen was trying to pull Karen to drive alone without John O'Keefe, to the way Higgins was texting John and saying, "Hey, you coming over?" and does triple question mark. Most guys do not put triple question mark like that in any kind of text messages. So very, very weird, strange, creepy stuff going on with these folks. And I could go on and on. Just Jen's whole behavior in the 911 call. You don't have to know who did what and how the setup began and all that. It started looking very shady and suspicious from the get-go, from that night, starting at the waterfall. Yeah, Nancy, has the Commonwealth has a solid case based on their evidence, and why would they care about ARCA? Exactly, bring it on. If I'm a prosecutor, I know that defense doesn't have a case. Bring your witnesses forward. I'll cross-examine, I'll impeach them, and I'll explain to the jury why they should still convict you if you're the defendant and I'm the prosecutor. Maya, you're saying last time the defense has to carry no questions at all. They should not allow a free pass for any witness. I know they did that with that Dr. Stonebridge was her name, that neurologist. They need to ask every witness at least something. Otherwise, it can look, the jury, I think it can leave the impression like, look, this testimony was so bad that they didn't want to bother cross-examining the person because it could get even worse. Hanker's story is absolutely set up from Chris Albert earlier today to Higgins texting John. They plan an ambush. Sandy says the Commonwealth has no case. I agree. PJ, okay. Maya says judges have practically absolute immunity. My officers have qualified immunity and get sued all the time, but almost no lawyers will sue a judge. That Kentucky case with a dead judge is a prime example. PJ saying it'll be another mistrial. Commonwealth won't want to retry the case. I think they'll keep retrying as many times as they can until they get a conviction. I think the only chance that can help counter this is to constantly have more and more public attention being drawn to this case. Ellie Espy, Brian Albert retiring to secure his pension payout in case he gets investigated and charged. He knew he'd be fired for misconduct. All that's very suspicious, from when he retires to the getting rid of the dog, changing out the flooring in the basement, all that kind of stuff. Too many coincidences. Sam, you're saying, I think Higgins just wanted to confront John. Reese shared text between him and Karen. Higgins knew this would cause a fight. Fight got out of control, hit head, died, cover up for it. Jeep Bureau saying, did John O'Keefe maybe have information on something corrupt that they were participating in as a reason to kill him? He was part of the sex offender registration program, part of the Boston Police Department. So from what I understand, that would only be involved making sure sex offenders that have to be registered as such, they're supposed to put on forms every place they live and update that information with the police department so that information can be put on public websites. And then they go and arrest folks if they don't comply with that. They do spot checks on them and whatnot. So if that's something that he was doing, I don't know how that directly implicate any of the other witnesses as any kind of corrupt practices. YouTube replier, we can speculate endlessly, but the bottom line is Commonwealth cannot convince the jury with no evidence. Yeah, I agree. When I initially started looking at this, I didn't really have an opinion whether Karen Reed was guilty or innocent. I even said, I never said she was innocent. And all I said was they didn't have the evidence necessary to convict. And the more I looked at this and studied it, the more I realized that there's more indication of evidence that she's innocent than anything having to do with her guilt. And Sandy, you're saying Brennan's withheld video and evidence this entire year, no consequence. Yep, that's right. They're the Commonwealth. They can get away with anything they want because the judge will just rubber stamp it. Yeah, I think also when you have cops making the kind of money they do up that part of the country, it's just mind-boggling. I think that sort of feeds their ego, and they think they can get away with stuff, and they're sort of like more like little warlords ruling over that part of the state there. Okay, if you have any questions, do red emojis, please. We'll keep going on a little bit longer here. Russian Aloha, you're saying it makes you physically ill, this case. Karen doesn't deserve any of this. Monique, also known as Coach Mo, why would Higgins assist John O'Keefe go to 34 Fairview when neither Karen Reed or John knew anyone there? They didn't really know him that good. And it was so late, and the snow is starting to fall, and it's a bad weather forecast. It makes no sense. Linda B, it says just the corruption that makes me so discouraged. Yeah, it is very discouraging. But they cannot convict Karen without a jury. So jury has to be the equalizer here. Yeah, see, the jurors in the trial one didn't give a hoot about Arca. Well, that's because you left a cop on the jury, and he basically bamboozled and tricked the other jurors into believing that Arca was hired by an insurance company for Karen, and they didn't want to have to pay any kind of liability in a wrongful death. So that's why you can't believe a word they say. And that's the kind of reasoning why Morrissey wanted Arca being hired by the feds to be kept out, because that gives them automatic credibility. If the jury would have known that Arca was hired by the feds, it'd have been game over. Karen Reed would have been acquitted across the board, even with that cop on the witness stand. But I've seen that many times where prosecutors will keep out evidence that should be considered by the jury, because the jury will otherwise do something else and believe something else wrongfully about the accused, the defendant, but it will assure a conviction, and that's why they do it. I remember watching a federal drug trial one time. They had an illegal that was charged with drugs, some kind of drug. I don't think it was manufacturing, but drug. He was like a drug mule that they were prosecuting, and the case was very weak. And the defense was trying to bring up the fact that this illegal entry person was going to be deported as soon as they were acquitted, and the prosecution wanted that kept out. And guess what? The jury did ask a question that we're saying, would he be deported if they find not guilty for this defendant on all charges? And that was kept out. The judge didn't give him an answer even when the jury had that specific question. So guess what the jury did? They came back and convicted the guy. So on some ash and trash evidence. So they were acting more as like immigration law enforcement types than they were actual deciders of guilt or innocence of the charges. So that's the kind of thing prosecutors do. This is the most egregious example, though, I can ever find. DS on YouTube, in your experience, do jurors pick up on witness body language, squirming in a chair, a big wrinkled forehead, or do they tend to look at for attorneys more? I think they do look at that. Most of them do look at that. I oftentimes bring it up in cross-examination, like that witness today that we saw, this Nuttall. I would have brought up some of the way he kept squeezing his eyes every time there was a zinger question that Jackson was asking him. So, and the way he's scrunching his forehead during key questioning as well. Sorry, SV is how long it would be for an appeal? Karen will be in jail for years. Yeah, she could possibly be there for a couple of years. Objection, Bevy, was it for Karen being sick or judge wanting a drink? The reason they stopped her, I don't know why they stopped so early. I mean, they should be going much later than that. That also drags this trial proceeding out when you have such limited hours during the day where this judge is not getting through this evidence. Lucas Knight, what was the point of Brennan showing a video to the jury between witnesses? He's trying to show all these, I think in between every witness, he's going to show, if he's got 44 videos of Karen, he's going to want to show snippets of Karen testifying. So basically, he's going to try to say that, see, this was different from this point. She said this one day, another day she says this. Trying to get any kind of potential inconsistency brought out. McGramble on. The one Albert had a reputation for sucker punches. You're talking about Brian Albert, the Boston cop. And don't forget, Reed had ghosts of the ATF agent Higgins. There was more than there was more than the dog. Sandy, yes, the Commonwealth, there was a request for continuation, but the judge never entertained it. What kind of continuation? I have not seen. I don't know if that's been posted yet on any website or Facebook or anything. Linda Mon, you're saying that Steinbeck Rose went to the camp I worked at. What camp was that? I have no idea. What camp and where, please? Okay, Stacey Q, you're saying new motion from Commonwealth about expert info before April 15th and to discharge the jury and returning to court on June 1st. Wow, they're going to have them come back June 1st, have such a big gap like that? That's really bizarre after I already started openings and got through the first witness plus a portion of another. Yeah, I think that there's a lot of stuff that cops have in their internal affairs files that does not get disclosed to defense for trial, and I think that's wrong. Yes, Jojo, the jury is going to visit 34 Fairview. At what point, we don't know yet, but they're going to be bussed there. So are you serious? Says the cops know better and they put egregious acts by a blue brother on paper. Lon Lit, you're saying the defense got the whole internal affairs file on Proctor because Hank sent it to them by mistake without letting first the judge vet it. Jerry Mitchell, I'm surprised the Commonwealth doesn't want to bring in snow machines from a local ski resort. Mark Snyder, you're saying you're way down in Georgia and this Massachusetts corruption is concerning to me. I can only imagine how upsetting it must be to Massachusetts residents. Legal to self-frustrating and infuriating about ARCA. All right, I'm going to go for a few more questions and then we'll call it a night here. Finishing up early. It's 4:34 Central Time here. Glamma Sue says Bev does not go past 4. She has a 1-hour lunch, 15-minute breaks, and starts late. So she essentially has 5 hours of total court in a full day. She also has half days and days off. Wow. Hey, there's a good question here from Ellie. Do you think the judge and her staff are looking through jurors' notebooks? I don't trust them in the slightest. They lock them up but have full access. Yeah, that's very concerning. I wouldn't worry about that with a normal court, but this court here, everything seems rigged. So I would not, if I was a jury, I would not put any notes down. I'd make them cryptic so no one could tell that what I was raising. Because if you put down like question marks after today, like in underlying certain things, like not all going from 2 to 3, and then now he's saying multiple other times as well, question mark, not credible or something like that, then you could find yourself as an alternate. Or worse, maybe they find something to get you booted off before you even make it to the end of the trial. Linda Mine, don't I remember Foster YMCA archery, the horse chocolate? No, that's not me. I don't know what you're talking about there. Sorry. What city is that in? I was never at some Foster YMCA camp or any archery and a horse. Yeah, basically that's true. This is a good way of saying it, Melanie. She's basically saying they violated court order based on Brennan's feelings, his imaginary beliefs. Oh, thanks, Robert. Faye, that's nice, y'all. You guys, thanks for your nice comments. I don't. Okay, well, Okoboji, Iowa. We've been to Okoboji, Iowa, but never to that kind of camp. So that's interesting. Went to a camp in Okoboji several times, numerous times, but not a Y camp. Yeah, we weren't from Iowa City. You can email me the pictures. We'll go from there. Anyway. She can't exclude ARCA based on Brennan's speculation. It'll be immediately appealable. Well, yeah, immediately appealable when? Or they may not. They may just wait until the end of the trial, and if she's convicted, then do it. And then she may be spending a couple years in prison. But I believe that they would be having a believe they'd be having some kind of expedited appeal process, though. So hopefully, it wouldn't be a lot of months that Karen would be in prison. Russian Aloha, is there any way the public can demand the FBI look into Judge Canoni, or is there something we can do to get her off this case? You're helpless. You don't know what you can do to help Karen win this. I would say just contribute to the defense fund. That's probably the best thing you can do. Keep talking about the case, keep following the case, tell other people about it. And, you know, the judge is the judge on the case, and you can't really get rid of her. If there was some kind of personal conflict with Karen and the judge, like if Karen did something to personally harass the judge, and that could be a reason the judge would have to recuse herself, but you don't want to have a client do that. You can't advise a client to do that. Yeah, I think that the judge, however biased she is, unless they got some kind of evidence of outright corruption to rig this process, or they're going to really leave a paper trail of that for this, it'd be probably very difficult to find that kind of evidence. Kelly, you're asking, would the Supreme Court hear about this case level corruption? You think that they would be interested in that? All right, I'll take one more question, please. Thanks for all your coverage on this case. California Girl 209, if the judge was accused of having a close relationship or friendship through the same close circle, wouldn't that be enough to have her removed? Yeah, she denied having any close connections with that, but yeah, family connections or close friend connections or any kind of ongoing connections with a party of a case should be a rise for a judge to recuse themselves for having a conflict. But the judge didn't admit to any of that on this case. I do think that they should have raised an issue regarding the McAlberts being connected through the judge and her brother representing. There's some kind of representation there that he represented somebody on a DUI manslaughter case. So yeah, political connections. That's what this case is about. I think is political connections. That's really driving the train here. Albert's black eye. Yeah, it's like a third world court. Our system is broken. Albert's black eye. All right, with that, I'm going to go ahead and sign off. And if I'm not on tomorrow doing live streaming, I'll do a recap in the evening and we'll go from there. I don't think I'll do a recap tonight. And it's been a long day, but thanks for all pursuing justice. Keep the faith that justice is going to happen for Karen Reed. We may have some really tough days and we may lose ARCA, but in the end, I believe that justice will prevail, and I'm not going to give up that hope and belief. So thanks for what you guys do to have belief and trust in justice as well. Y'all have a good night. Be safe.